Good morning, everyone. I'm going to wait a little bit to get started to make sure everyone's fully connected who's joining us today.
Hi, Nicole. This is Marley. Can you hear me?
Yes, I can hear you.
Okay, great. So sorry about this. So I'm just gonna keep this on in the background on my phone in case we need to communicate.
Great. And are you the iPhone in the room?
I am the iPhone in the room.
Okay, great. Wonderful. Thank you. And for everyone's knowledge, we do have a court reporter joining us today, Ms. Marley Nelson. Um, so you all know that.
Thank you so much.
Thank you. And let me know, please, if at any point you need us to slow down or take a break or anything like that, please don't hesitate to speak up or spell something, all those things.
Absolutely. Okay, thank you so much.
Thank you. I see a few more folks are just joining the room, so I am going to wait a little longer.
David Sandino joining with DWR.
Good morning, Mr. Sandino. We haven't started yet. We're just waiting for everyone to get into the room. The
Thank
virtual
you.
room. Thank you. All right, I'm going to call it as a critical mass. It looks like 51 in the room. So we'll go ahead and get started. I have some introductory remarks, and that will take a little bit for us to get through for anyone who's still trying to connect to join us today. Good morning. It's April 10th, 2024. I am Nicole Kinsey, the presiding hearing officer for the Administrative Hearings Office of the State Water Resources Control Board, and I'll refer to my office today or throughout this proceeding as the AAHO. This is a pre-hearing conference on the pending petition for assignment of state filed application 25517 and accompanying water right application 25517X01 and the pending request for release from priority of state filed applications 25513, 25514, 25517, the unassigned portion, 22235, 23780, and 23781 in favor of water right application 25517X01 of Sites Project Authority. This pre-hearing conference is being conducted by Zoom web conference. It is also being broadcast live on the AHO YouTube channel. So I would ask, if you are not planning on participating, by which I mean speaking in this proceeding today, if you would move, and you're on the Zoom platform, if you would move over to watching the live streaming on YouTube, that would be helpful. It just helps me manage all of the participants in the room so that I can't actually see all of you on my screen, but it helps me scroll through. Both the audio and the video of this proceeding is being recorded, and we will post files of the recording along with the Zoom generated transcript to the administrative record that is available on the board's FTP site. The YouTube recording will also be available on the AHO YouTube webpage. And as I mentioned, we do have a court reporter joining us today, so that transcript will be made available once we have it, and we will post that transcript to the board's FTP site for this proceeding as well. If at any time today you're experiencing technical difficulties trying to communicate with us, please send an email to the AHO, and that's the AHO inbox admin HRG office at waterboards.ca.gov. There are staff of the AHO who are monitoring the inbox in real time, and they can let me know if you are having technical difficulties. Assisting me today are several staff of the Administrative Hearings Office, as well as the Division of Water Rights and the Office of Chief Counsel for the State Water Board. We have Nicole Mullen, Skylar Anderson, and Kyle Wooldridge from the Administrative Hearings Office, Elena Hartman from the Division of Water Rights, and Dana Heinrich from the Office of Chief Counsel. And if at any time today during our conference I am experiencing technical difficulties, it does occasionally happen, and I'm not able to rejoin the Zoom conference within a few minutes, one of the team will call a recess until I'm able to rejoin. Next on my list is to move to appearances so we can see who is participating today. And you will all have a chance to introduce yourself. To do that, I'm going to move through the list of persons and entities who filed NOIs, and I'll start with the applicant, and then I'll roughly go in alphabetical order so you can prepare yourselves. It may not be perfect alphabetical order. And then we will move to the interested persons to the extent these interested persons are on the call today. As we proceed, if you would, please keep your microphone muted except when you're speaking. That will be helpful to minimize background noise. And then in terms of expectations today, I did just want to say, I'm not sure how long we'll go. We have a lot of ground to cover. So we will take breaks as needed for everyone. Please don't hesitate to let me know if you need a break. And then hopefully it won't be necessary, but if we do get to lunch and we need to keep going after, we will take a lunch break. I'll probably keep it short, half an hour. Normally during our hearing proceedings, I'll give you a full hour for lunch because I think it's important, you know, we're all busy and there's other things you need to do. And also it's important to eat lunch. But just for today, so we can get through this, if we do hit the lunch hour, I will make it just a half-hour break. All right, and now back to appearances, as promised. I will look to the room and I will start with the Sites Project Authority.
Yeah, good morning, Hearing Officer Kinsey. Andy Hitchings for the Sites Project Authority, petitioner and applicant. And maybe for efficiency, I'll also introduce and note the appearance of my colleague and partner, Aaron Ferguson, also from Somex Simmons and Dunn, and Allie Forsyth, staff for the authority. Thank you.
Thank you, and good morning to all of you. Aqua Alliance. Do we have Mr. Jackson or any of the other?
I don't. This is Chris Schutz with CSPA. I don't believe that Aqua Alliance is going to be represented in person this morning. I can represent them such as it is.
Great. Thank you, Mr. Schutz, and we can. Thank you. Appreciate that. California Department of Water Resources.
Good morning, Presiding Officer Kinsey. That sounds very formal. Yeah, I'm here. My name is Eric Soderlund on behalf of the California Department of Water Resources. Also, I see David Sandino, Janice Wu, Robert Cook, and I believe Jabruti Maroney. Good morning, and we're here.
Thank you. Good morning, Mr. Sutherland. I will, for efficiency, as we move through this, and I have a note in my script here, I will note that DWR did request to be granted party status in this proceeding, although DWR is not a protestant to the application or the petition. I am going to grant party status given the interests of the Department of Water Resources in operations in the Delta and such. It just makes sense. So I'm going to go ahead and make that formal. It will be reflected. There's going to be some kind of ruling or amended hearing notice or possibly both that comes out of this proceeding, and we will reflect the grant of party status in writing in that document.
Thank you.
Thank you. California Sport Fishing Protection Alliance.
Chris Schutz for the California Sport Fishing Protection Alliance, and Mr. Mooney is here too.
Yeah, also Donald Mooney on behalf of California Sport Fishing Protection Alliance.
Thank you. Good morning, Mr. Schutz and Mr. Mooney. California Water Impact Network.
Again, I don't believe they're present this morning, but I can be their placeholder, such as it is. Thank you.
Thank you, Mr. Schutz. Cal Wild. And this is a note maybe for those of you, if you know, I have down Mr. Evans, Steve Evans. We received an NOI from Cal Wild, but I have a note here that it was incomplete. I think some of the contact information may have been incomplete. So if you are in contact with Cal Wild, you would please let them know to file an complete NOI as soon as possible. That would be helpful. Center for Biological Diversity.
Hi, good morning. This is John Bussey for the Center for Biological Diversity. I think my colleague Frances Tinney is also on. She may have gone over to the YouTube to view, but we're here. Thank you.
Thank you. Good morning, Mr. Bussey. Central Delta Water Agency.
Good morning, Dean Reese for Central Delta Water Agency, South Delta Water Agency, and Zuckerman Mandeville, Inc., etc.
Did I note that wrong? So I'm sorry. Can you, I want to make sure I get this right. You're representing Central Delta Water Agency and others
South
as well?
Delta Water Agency, Zuckerman Mandeville, Inc.,
Okay.
Delta Farms Reclamation District number 2030, and Rudy Musi Investment, LP.
Great. And thank you, Mr. Reese. Was that was reflected, I assume, in your NOI? I may just not have noted that down correctly.
It is, yes.
I will fix that. Thank you. County of San Joaquin.
Good morning, Ocean Reserve for San Joaquin County.
Thank you. Good morning, Ms. Meserve.
Good morning.
Fly Fishers of Davis. Friends of the River.
Donald Mooney on behalf of Friends of the River, and I think we have some other folks from Friends of the River here. I believe Ron Stork, Doug Manor, and Jan Dorman.
Thank you. Good morning, all. Oh, yes. Thank you.
John.
Northern California Council of Fly Fishers International. And then I will, next I have a list for you, Mr. Spain, but I will go through it. Pacific Coast Federation of Fishermen's Associations, Institute for Fisheries Resources, San Francisco Crab Boat Owners Association, North Coast Rivers Alliance.
That is correct. I'm appearing for all four.
Thank you very much. Good morning. Restore the Delta. Next, I have another a group here, San Francisco Baykeeper, Defenders of Wildlife, the Bay Institute, and Golden Gate Salmon Association.
Good morning, Eric Busher for San Francisco Baykeeper and the group. Some others with us as well.
Ashley Overhouse with Defenders of Wildlife. Good morning.
Good morning.
Scott Artis with Golden State Salmon Association. Good morning.
Thank you. Good morning. Save California Salmon. Sierra Club.
Donald Mooney on behalf of Sierra Club.
Great, thank you. State Water Contractors.
Good morning, Jenna Mandel Rice on behalf of the State Water Contractors, and I'm joined by my co-counsel today, but they are on the YouTube channel.
Great, thank you. And Ms. Mandel Rice, I have my this note here. I received your request to appear on behalf of the State Water Contractors. That is certainly fine with me. I assume you will comply with the appropriate rules related to representing clients in different states, but in terms of our process and procedures here, I have certainly no objection to that. So thank you for joining us.
I will, thank you.
T&M King Farms.
Ben King for T&M King Farms.
Thank you. Good morning, Mr. King.
Morning.
Trout Unlimited. United States Bureau of Reclamation.
Ray Sahlberg, Bureau of Reclamation.
Thank you, Mr. Sahlberg. And I also have this note here, similar to the Department of Water Resources. The Bureau of Reclamation requested party status in this proceeding, even though they are not a protestant to the application. And given the interests of the Bureau, I am going to grant party status, and that will also be reflected in the written procedural ruling or amended hearing notice that comes.
Okay. Thank you. We appreciate it.
Thank you. Good morning.
Good morning.
Water Climate Trust, Waterkeeper Alliance, and International Rivers.
This is Conrad Fisher on behalf of Water Climate Trust, and the other entities on our protest are not here, but they would like to remain parties, and they include Waterkeeper Alliance, International Rivers, and the Winnemem Wintu Tribe.
Thank you. Thank you, Mr. Fisher.
Yes.
My next call was for the Winnemem Wintu Tribe, so I will note their interest to remain a party. Richard Murat. Clark Ombaum. And please, if I mispronounce or misaddress any of you at any time in this proceeding, please correct
Clark
me.
Ornbaum. I'm here.
Thank you. Good morning, Mr. Ombaum.
Good morning.
And I'll look to my team. I think we have the iPhone unknown. We can now identify as Mr. Ombaum. I think they will make a change to reflect that. And then Patrick Porgins. Great. That is the list of NOIs that I received that either are reflected party status or requested party status. Is there anyone or any party that I missed? I'm not getting to those who intend to present policy statements, but anyone who I missed who intended to participate as a party. And if you would, you can come off mute and feel free to speak up. All right, I think I'm not sure it makes sense for me to go through the full list of those who requested the opportunity to make policy statements during the proceeding. There's a long list, and you certainly will have the opportunity to do that. And you're welcome to participate in this proceeding today. But I think what I'd like to do is look to the room. And if you are on the call and you have not yet had a chance to introduce yourself, if you would raise your virtual hand, and I will invite you to introduce yourself. Giorgio Curti, please introduce yourself and let me know who you are representing today.
Thank you, Nicole. My name is Dr. Giorgio Curti. I am here to work in the interests of and to the concerns of the Colusa Indian Community Council.
Thank you very much. Welcome.
Thank you.
And Dr. Curti, had you filed an NOI in this proceeding? I'm scanning through my list.
No, the tribe got notification fairly late of this process, so it was after the opportunity to file. So I'm here to listen in, and I understand there's formal procedures in terms of who can speak and who cannot. But as a federally recognized sovereign and self-determined government, we feel it's fundamental that Colusa has the opportunity to sit at this table.
I think it would be important. So I would ask if you would please file an NOI. That would be quite helpful, and then indicate in that NOI whether the request is to participate as a party in the proceeding. And in that case, I would ask for an explanation, which probably is exactly what you said to me, as to why the NOI is late. But it's helpful to know that you didn't receive notice. That would be helpful to know. And then, or in the alternative, if the intent is just to present a policy statement, a non-evidentiary policy statement that can be reflected in the NOI, and then we can incorporate the tribe into our process. Thank you. I would appreciate that.
That's appreciated. I'll speak with the chairman, vice chairwoman, the executives, and we will get that to you in due time.
Thank you.
Thank you.
And I'm looking back to the room, and I'll just make this as a general call. Is there anyone else who's on the Zoom call and who plans on participating who has not had the opportunity to introduce themselves this morning? Alex Beering, please.
Hi, yeah, good morning. Sorry, I'm just audio this morning, but from California Farm Bureau, and we do intend to make a policy statement as an interested party. So just wanted to introduce myself for those I didn't know, and look forward to seeing all you through the process.
Thank you. Good morning. I'm looking to the room. Is there anyone else?
Yes, this is Patrick Porgens.
Mr. Porgens, welcome.
Thank you.
Thank you. And I also wanted to mention, this goes for everyone, but this is going to be a long process. We're going to spend a lot of time together. And I know we all have our lives that we are also doing on the side. So I'm prompted now to say if there are, there's a formal reasonable accommodation process, but if there are informal things that I can do in this proceeding to work with you, and this goes to everyone on appearances, especially if any of you have health challenges, please, let me know how I can make this process so that it's accessible to everyone. All right, with that, I plan to jump into the meat of things. I have a number of housekeeping items to go through, and then we have all of the questions that I had asked in the hearing notice. So I'll start with the points that I have noted down. The AHO issued a notice of public hearing and pre-hearing conference for this proceeding on March 1st, 2024. If any of you have not seen or read that notice, I encourage you to do so. It is long, but it's sort of unavoidable, but it does lay out our process as we anticipate it so far. In the notice, I identified several topics for discussion for today that I thought would be helpful, and we'll get to those. But I just wanted to emphasize first that we are focused here on the procedural matters so that we can structure this hearing to proceed fairly and as efficiently as possible. So that's really the focus of what we're talking about today. We are going to talk about hearing issues and that kind of thing, so the procedure strays over into substance to some extent, but I do want to avoid, to the extent possible, substantive arguments. That those belong in the hearing process or in closing briefs. I did want to briefly describe the general process for this hearing. I know many of you have participated in AHO proceedings before, and many of you have not. I will be presiding as the hearing officer for this proceeding, and that's in accordance with an assignment made by the board's executive director. The board members themselves may appear at the hearing at times on the Zoom platform, but we will never have a quorum of the board present. And I will be presiding over the hearing process throughout. And my role and the role of the hearing team is to run the hearing process and develop through that process the evidentiary record that the board will rely on when making a final decision on this application and the associated petitions. After the evidentiary portion of the hearing is complete, the AHO and the Division of Water Rights staff who are on the hearing team will prepare a written recommended decision for the board, and the parties, all of you, will have a chance to comment on that recommended decision. And then at a regularly scheduled board meeting, the board will consider the recommended decision and decide whether to adopt it, whether to make any changes to that recommended decision, or whether to send the matter back to the AHO for additional proceedings. So I wanted to be clear about who the decision maker is here. I will be making certain procedural rulings and determinations throughout this process, but ultimately on the substance, the board will make will be the final decision maker. On another housekeeping matter, I did want to note that the AHO and the Division of Water Rights have received and probably will unavoidably continue to receive occasional communications that are related to this proceeding and the site's reservoir project that are not CC'd to the entire service list. That does happen. We try to avoid it, but it happens. We try to avoid it because of the prohibition on ex parte communications, which is very important to maintain the fairness of this process. So I wanted to let all of you know that if this does happen and we receive a written communication that has not been CC'd to the service list, we are saving those communications in the folder for this proceeding on the FTP site so that they are available to all of you and you have a chance, if necessary, to respond to those. So I wanted to encourage you to regularly check our miscellaneous communications folder because we're going to continue to keep that updated as any such communications come in. But we will make all of those available and disclose them all to you. I also wanted to just briefly remind all of you and ask all of you, both as parties and interested persons, to not communicate with the board members outside of this hearing process because it is an ex parte communication. And for example, I would ask if you would please not speak in the public comment portions of the board's meetings about this proceeding. It is technically an ex parte communication because the other parties don't know that that's going to happen and don't have a chance to be there and to respond, even though it's a noticed board meeting. We then would have to take steps to address that communication. We would, and if it does happen, what we will do and have done is add a video clip of that portion of the board meeting to the record for this administrative record for this proceeding so that other parties will have the opportunity to respond. But I wanted, if I can ask to keep us organized, to keep our discussions within the boundaries of this proceeding. Anything related to this process and this hearing is most appropriately addressed to me, ideally in writing, or if we're in a hearing, we can discuss online that way. But in writing with a CC to the service list, and if you must communicate with the board, doing so in writing, and again with the CC to the service list would be the most appropriate way to do that. And I am going to, all of you will have a lot of chance to talk today, so I apologize for just marching through this background. I did want to note that the AHO received pre-hearing conference statements from the authority, that's the applicant and petitioner, from CSPA and Friends of the River, from T&M King Farms, San Joaquin County, and Central Delta Water Agency. I did read those. I found them to be helpful. And we can discuss further as we get into the issues today, but I wanted to note for the record that we did receive those and I did read them. I have a few additional specific things that have come up before we get into the list of issues that I wanted to address today in the hearing notice. And then once I go through my specific issues, I actually am going to look to the room to see if there are general questions about the process that I can answer. This is our chance to do that. I know sometimes it's easier to just talk about it now than having a back and forth exchange in writing and jamming up everyone's email inbox. So I will look to the room for that once I get through my list of specific questions. I did want to note, first of all, I'm going to put you on the spot, Mr. Borgens, not in a negative way, in a good way. We had an email exchange where you raised a question about ex parte communications, and I just wanted to turn to you to give you a chance. If you would explain your question, I want to respond to it, but I'm not sure I understood it. So if you would like to ask your question now, this would be a great time to do so, or we can turn back to you later, as hopefully the group there. Mr. Porgens. I'll turn back to Mr. Porgens. The next item on my list is an order of proceeding. I realize that, Mr. Porgens, yes, please.
Yeah. Yes, my concern was during a previous You gotta forgive me, I got something wrong with me today. At any rate, we had an ex parte communication problem in a prior proceeding. And it was noted. Now, in this situation, we're dealing with an entity that is more or less, how am I going to find out if they're doing ex parte communications? I mean, because I'm going to have to go to the sites, people that are proposing the project. Do you understand what I'm trying to say here? How are we going to know that they're not doing ex parte communication? How are you going to determine that?
Thank you, Mr. Porgens. I think and you can follow up with another question, but what I'm reflecting to you today is that if the board, any of the members of the hearing team receive any kind of ex parte communication from one of the parties for from an interested member of the public, any of that, we will note that communication. First of all, we'll try to avoid it. Second of all, we will note that communication on the record for this proceeding. If it's a written communication, we will include that written communication in the administrative record. If it's an oral communication, such as a phone call or a voicemail, we will include a recording of the voicemail. If it's an oral communication that's not recorded, we will include a summary of what that communication consisted of, who was involved, and every party to this proceeding will have an opportunity to respond to any communication like that that does occur. So that is my representation to you, but I want to make sure that that fully answers your question or your concern.
No, we'll have to see what happens as we go forward here, because we had the board in ex parte communications on the last proceeding that I was involved in, and there's one other thing I would like to address it right now, because I have to go to a doctor. Is that on page 6 of the notice, it says that, and I'm paraphrasing now, it says something to the effect that if this project may have some impacts, on other users and on the Delta and so forth and so on. My concern is that it will have an impact. It definitely have an impact. And the reason why I say that is because we have to look at the condition of the Delta as it is presently. And we're talking about a significant amount of water that's going to be stored up in that reservoir. And my concern is that push comes to shove, the board doesn't have a really good track record, in terms of enforcement. I've only been around 45 years, so I know what I'm talking about. So my concern here is that it will have an impact. There's no question about that. I didn't put any, try to compromise or sit down with those people, because as far as I'm concerned, until this board comes up with a full water rights adjudication on that river, and until we get compliance with, what's to get back in some sort of remnants of what it should be, and until the board takes affirmative action to protect the waters of the state, which it has failed to do, and that's all in the record. So I'm just letting you know now that I'm not going to be pulling any punches here. The state of the resources is deplorable, okay? It's deplorable. And so we're going to be tapping into the Sacramento River for more water. There's 8 different projects right now that are trying to tap into water from either the Sacramento River or from the Delta. This is we're taking this in bits and bytes. We're not going to get anywhere until we go back to what I said in 1970s. We need a full-blown water rights adjudication. And if we don't have that, we're piecemealing. So that's all I want to say at this point, and you'll be hearing from me in the future. And forgive me for not being articulate today. I'm just not at my best.
Thank you, Mr. Porgens. I think I look forward to seeing your best, because I think you're quite articulate. And I appreciate that this is the proceeding. This is the opportunity. Please do submit the evidence into the record. That's what we're doing here. That's the purpose of this proceeding, is to gather the evidence so that the board has a complete record to consider. There are some elements, I think, that we are going to have to deal with the situation that there are multiple proceedings affecting the Delta at one time, and this is just one piece of it. And my jurisdiction, if you will, or authority is with respect to this proceeding. And this may be a situation where their communications are appropriate appropriately addressed to the board about the larger picture, but I would ask once again a CC to the service list so that we are all on the same page as to what is being said to the board that may affect this proceeding as well as other proceedings.
Okay, I'll send you my comments and, so more succinctly, so we'll all understand what I'm talking about, okay?
That's fine. We will consider it as in a way as an opening statement. Thank you.
Thank you so much.
Thank you,
That's
Mr.
to you, by the way. You're gonna have your hands full.
Thanks. Mr. Hitchings, thank you for your patience. I see your hand is up and you're welcome to speak.
Yes, thank you, Presiding Officer Kenzie. Just 2 points. In response to Mr. Porgan's comments, I just want to note that the Sites Authority has adhered to the ex-parte rules and intends to continue to do so. Our understanding is that all the participants will as well. So I think with that and the fact that board staff and the hearing office staff will share any ex-parte communications, hopefully that'll allay the concerns stated. Also, just a procedural point, we raised this in our pre-hearing conference statement, was that our understanding is Mr. Porgans didn't submit any information supporting party status. And I don't know if anything's been supplemented on that, nothing that we've seen. So we have requested that any party or entity that has not provided justification for party status not be granted party status unless that occurs.
And maybe a point of, if I can respond, just for a point of clarification, Mr. Hitchings, my understanding is Mr. Porgans is a protestant to the application and the authority's petition. Is that your understanding as well?
No, I'm not aware that he filed a protest by the protest deadline.
I see. And Mr. Porgans, is that does that fit your understanding? That do you believe you filed a protest? I can look.
No, I did, and I got confirmation that I filed all the required documents from a member of the board, the staff, that I filed all of the appropriate NOI documents stating that I'm a participant. Maybe he didn't get it yet.
Well, yes, you did file a notice of intent to appear as a party in this proceeding. And this is what I would ask, Mr. Porgans, when you have an opportunity, if you would provide in an updated or a supplement to that notice of intent to appear that explains why you think you should be granted party status, even though you did not file a protest by the deadline for the protest period, which was back in, I'm going to look to my team to help me, for Mr. Hitchings, you may know, October, September, in there, August 31st.
August 31st, yes.
Yeah.
Thanks.
August 31st. That doesn't mean you can't be granted party status here, but I do ask that you provide a justification that then I can consider, and then we will make a determination on that.
Okay, I'll make this clear. I've been under doctor's care for the last 7 months. So maybe I could have possibly overlooked that, but I will send a supplement saying why I'm protesting this project.
And the fact that you have had health challenges would also be a helpful justification as well.
Yeah, thank you so much.
Thank you. And Mr. Porgans, I'm sorry to turn back to you. I know you have other things going on and that you're managing. Would it be possible to get that notice to us within the next week by the 17th of April? Does that make sense to you?
Yeah, I'll do my best to do that. 17th of April. And a notice of protest is what you want.
A supplement to your notice of intent to appear that explains why you should be granted party status.
Okay.
Please. It doesn't need to be long. Thank you.
Okay.
Ms. Meserve, I see your hand, please.
Thank you. I just wanted to respond really briefly to the request not to appear at open public comment regarding, and I know I was one of the people, I don't know if anyone else did. I went and I made a procedural, I was very clear that it was a procedural comment regarding all the matters that are impacting the Bay Delta right now. And for those of us who are advocates or groups, it's really unworkable what's going on. And I know that's one of the hearing questions about whether dates can be changed or whatnot. And I guess, I mean, I totally understand your request. And I think, I personally will try to keep it to a dual roar, but I'm not going to give up the right to be able to address the board on issues that are really policy matters that are much larger than this hearing alone, so I understand there's a careful balance that needs to take place. And I appreciate the fact that your staff had to take the time and clip my statement and put it into this hearing box and whatnot. But I just want to say it does trouble me a little to have everyone here be told that they should not be addressing the board, especially if we take care to not be addressing the merits or the substance of anything, but really just talking about, the overall impact on the community that's trying to work on these issues, to have all these dates piled up on top of each other. It's really unworkable for us. And I think that's an important policy concern for your, and I want to be able to raise that and when necessary. And I did feel it was necessary. So I just want to make that clear. Thank you.
Thank you, Ms. Meserve. Your points about the larger picture here and all of these proceedings that are going on are really, they're well taken. And I appreciate your professionalism. I have no doubt about that. And I didn't mean to imply that there was anything inappropriate about that. That's why I tried to frame my request as a request. It's just a request. It's a please, when possible, put it in writing, because it does, I think, make the communications more transparent for everyone. But when necessary, my team will be, we need better video clipping software as part of it, but we'll work with DIT on that. But we will make it part of the record, and so that everything is transparent and is out there for everyone to see. But I do appreciate that this proceeding is not occurring in isolation. There's a much larger picture here. And I acknowledge that there are limitations on my authority, and there may be times when it really is an issue for the board to address. So I appreciate your comments and understood. Thank you. Mr. King, I will go to you, and then I will turn to you, Dr. Curdy.
Yes, thank you. So around what Ms. Meserve mentioned, it's a very complex issue, a lot of interrelationships. And so I was intending to make a public comment for the volunteer agreements hearings coming up next week before the board, but I will not, just to make sure that we're in accordance with ex parte proceedings. But I think Ms. Meserve really stated it really very well, that this project, which I think is a very important project and concept I support, it has a lot of interrelationships, and there's a lot going on right now, and I do believe we need to move expediently, but also I think you can appreciate it's hard to just focus on one thing and not another thing. So in deference to proceedings, I will draw my any public appearance for the board, but I appreciate the issue of bringing up the issue of the complexity of that what we're facing here as you make your determination.
Mr. King, I certainly don't want to discourage you from participating with respect to the voluntary agreements. That is not my intent at all. I don't want any we can work within the framework, recognizing that this is complex, they're all interrelated. We can work within that framework. I certainly don't want to discourage anyone from fully participating in any of the other proceedings that are going on before the board that somewhat interrelate here. As Ms. Meserve pointed out, I think very articulately, it can be done with care and respect for the ex parte rules and this proceeding, but I recognize it's complicated. So maybe I overstated my admonition and my request, not admonition, request. But I just wanted to have that discussion on the record with all of us together. It's complicated. We're going to do our best to make sure everything ends up in the record, but please don't take what I said as any kind of discouragement to fully participate in the other Delta related processes that I realize are happening at the same time. Dr. Curdy, and then I will go to you, Mr. Schutz.
Yes, thank you. Ms. Meserve and Mr. King bring up vital points. And when we consider this in the context of the Colusa Indian Community Council as a federally recognized tribe, there's government to government relationships and responsibilities, both at local and state levels. And some of these board members, of course, are part of these governmental entities that have obligations and responsibilities to the tribe. So I just think it provides another layer or other layers of these complexities that Ms. Meserve rightfully identified. And so I think it's fundamental to consider the status of tribes, federally recognized tribes, California tribes, and all the rights and opportunities that these agencies, including the board and the board members and Sites Authority as a state entity, holds for tribes and to tribes. Whether that's being respected or not is a whole nother matter I'm sure will come up. Thank you.
Thank you, Dr. Curdy. Mr. Schutz.
Yes, in a previous process in which ex parte was in play, one of my adversaries announced to the service list prior to appearing before the board that he was going to do so and make comments on a matter that was under the limitations of ex parte. To what degree would that kind of advisory notice to the service list fulfill the requirements to avoid ex parte when one is preparing to address the board?
That's how, thank you, Mr. Schutz. You always have thoughtful comments. I think that would be quite helpful. My request would be, when possible, make any comments in writing, when appropriate, understanding that there are appropriate times when the board needs to be addressed, particularly when the issues you're addressing are, they may involve sites, but they're with respect to a broader issue of the Delta. I think notifying courtesy notifying the service list would be quite helpful and would very much be appreciated. I don't think it fully, there's some challenges with that in the sense that it's not an officially noticed, if the courtesy notice comes out the day before, there may still not be an opportunity for everyone to participate, but it's certainly helpful. I think as a matter of professionalism, it would be greatly appreciated. And that may be a helpful thing to do. So thank you for that note. With that, my intent is to continue through some of these. We haven't even gotten started, but this is great. But continue through some of the notes I had. Once again, I said once before I even get to the questions on the hearing notice, I'm going to look to the room for any additional procedural questions, and we'll also circle back to that at the end. But I did want to talk about an order of proceeding. I realize I did not raise that in the pre-hearing conference issues, and I should have. When we're presenting case in chief and then eventually rebuttal, and then also an order of cross-examination. It's been my practice to generally use the same ordering for all of those because it just sticks in our minds better. My presumption is that the applicant would present their case in chief evidence first. Does that, Mr. Hitchings, does that make sense to you?
Yes, that makes sense, and we expected that would be the case.
Great.
Thank you.
So we've at least clarified that. Now, in terms of how do we go next? But this doesn't have to be a final decision, but I wanted to open up the issue so we can talk about it. I also wondered whether there are groupings here. And again, I'm not asking for a commitment, just a discussion, at least an initial discussion of the groups that may line up for purposes of presenting case in chief evidence, and then also for cross-examination. The natural groupings relate to the protests, of course, that there were a larger number of protestants than protests because many joined the same protest, which is quite helpful. So maybe here's what I was generally outlining, and you can tell me how we can do this better. I was generally thinking we'd hear from the applicant and then we'd turn to the other parties who have what I would call water rights interests. I know there's a lot of overlap with water rights and water quality and fisheries, and it's all blended together, but generally thinking state water contractors, Central and South Delta water agencies, County of San Joaquin, T&M King Farms, and I should add here, I think DWR and the Bureau of Reclamation, possibly. Well, maybe it makes sense to have DWR and the Bureau present any evidence immediately after the applicant, since they're, I think, generally in support. Does that, I'll look, Mr. Soderlund, is my understanding correct that the DWR's position is somewhat aligned with the authority? I don't mean to put you in a box in any way, but what do you think?
No, I believe it's fair to say that they're in line. There's been a lot of coordination work over the years. Obviously, it's not the same interest, but I do think that we can inform the project and inform on some of the issues that were in the hearing notice. So I do think it makes sense to have us go around that time.
Okay, thank you. And then I'll look to the representative for the Bureau. Do you have anything to add to that about presenting any evidence that you may have after the authority?
If we do have any evidence to put on, I guess it makes sense to do it after the authority. I would agree with that. I'm just not sure at this point if we will be putting on any evidence at that point.
Right. Thank you. And then Mr. King, I see you have your hand up, so I'll go to you next.
Yeah, so
what do you think makes sense for you?
Yeah, well, thank you. I think that's a good beginning. I would add of course, depending on what Mr. Ornbaum wants, I consider his protests in conjunction with the water rights. I know I look at it as the water rights regards the groundwater and the human right to water for disadvantaged community at College City and the recharge of general area around Sycamore Sloughs, importantly. And then also, of course, I'll defer to Dr. Curdy, but the reserved federal rights of the Coosa Indian community, I believe they also are diverters on the Coosa Basin Drain, and their federal reserve interest rights should be respected. And also it'd be great to consult with them regarding the water rights and generally, and especially those particular to the historical Coosa Trough. So I don't know if Mr. Ornbaum agrees with me or not on that, or what Dr. Curdy says, but at least in my perception, if they felt appropriate, I would think there'd be appropriate grouping from my perspective.
Thank you. That's helpful. And as we're talking about this today, like I said, I'm not going to make a final decision on order. We have a little time, but if at any point all of you as parties get together and decide that a certain ordering or arrangement makes sense to you, more than likely that's going to make sense to me. So please feel free to come up with your own preferred ordering of things. I will turn next to Ms. Meserve. Do you have any thoughts about where San Joaquin County should fit in?
Thank you. The county intends to coordinate with Central Delta Water Agency Group. So chances are we'll be doing our evidence and in a grouping, and that's not to say we might not group with others. I would defer. I mean, I think since I haven't thought about this issue a lot, honestly, so I'm not sure I'm totally ready to respond, but I would ask to see if Mr. Ruiz has anything to add.
Yeah, this is Dean Reese for Central Delta. I think a grouping with San Joaquin County makes sense. I think we're going to coordinate, and so I think that makes sense.
Great, thank you. And you can let me know more about that as you work things out. Did I miss anyone, in addition to the notes that Mr. King made? Did I miss anyone or any other party who generally would be in the potential injury to water rights category?
I believe you mentioned state water contractors in your initial list, but just wanted to confirm.
Yes,
I think
there you
we
are.
would appropriately group there. Thank you.
And if I can follow up on that, what would the general alignment is? What does it make sense to group you with DWR and not by group? I don't mean make you present as a group, but generally order with DWR and the Bureau. Is that a general alignment, or?
Yeah, I think our position will be different, but in terms of order and discussion of the water rights that state water contractors are concerned about, it makes sense to group us with DW Water.
Okay, thank you very much. I appreciate it. And then there are generally the environmental interests, which there's of course a wide range. And I don't know amongst, maybe what I'd ask is amongst, oh, Mr. Ornbaum, please, I see your hand is raised.
Yes, I don't know if that was a spot for me to jump in, but with my protest, it is for water rights, for the county, surface water rights, the natural point of origin, the natural runoff. And that does recharge our groundwater. And so it's all in my protest. So just to reiterate what it says in my protest.
Thank you very much. And thank you for your comment here to make sure we have you here. I do.
Thank you.
So I'll look to the remaining groups. I know there are other individuals listed here, but the other remaining groups, I don't want to necessarily pick on anyone, but if any of you have any ideas about ordering for what I'll call the environmental interests, or what I may ask you to do is confer amongst yourselves and then put together a proposal as to what order you think would make sense. Does anyone want to speak up on that?
Excuse me. Hearing Officer Kinsey, this is Eric Busher at San Francisco Baykeeper. I was going to make that same suggestion that there's a lot of us on and off this call, and I think we can propose an appropriate order to try to streamline some of the overlapping evidence that our groups will present.
Great, thank you.
This is Don Mooney, and
please,
on behalf of Sierra Club, California Sport Protection Alliance, Sport Fishing Protection Alliance, and Sierra Club, and I agree. I think we can kind of coordinate and send a proposal.
That would be great, and please do in your consideration not only of the ordering, but whether or not, in terms of cross-examination, it's sometimes more efficient to have fewer people conduct cross-examination, especially where the issues overlap. To the extent you can come to agreements about that, I think that would be quite helpful. That's another issue to discuss. And let's circle back to this. We have other conversations about deadlines, but I would like to set a reasonable deadline for all of you to submit proposals about ordering the order of the proceeding, at least with respect to the parties you're most aligned with, and then also if there are groups for purposes of cross-examination, that would be helpful too. And I'm putting a note here to come back to this deadline in this conference. I'm just not going to set it right now because I think we should think about it.
Ms. Kinsey, this is Chris Schutz. Sorry to interrupt. I believe a couple of parties have joined that haven't announced their presence and that you might want to pick up.
Excellent. Thank you, Mr. Schutz. If you have joined us and we're not here for the statement of appearances and have not had a chance to introduce yourself, if you would raise your virtual hand, I will invite you to introduce yourself. Wonderful. I see Save California Salmon.
Hello, sorry. This is Regina Chicazola with Save California Salmon, and our attorney is also here. And sorry, we were actually on the YouTube link, not realizing we had to do the roll call, and apologies for that. But I'll pass on to.
Thank you. Good morning.
And I'm going to confess, I can't on my current Zoom find my hand raised feature anymore, so I apologize, but I'm Matt Clifford representing Trout Unlimited.
Thank you, Mr. Clifford. I know that, yeah, they change every time I get used to it, it moves. Thank you. And Castle Willie, also Save California Salmon, I see.
Yes, I'm Save California Salmon staff attorney.
Thank you. Good morning, welcome. Is there anyone else who hasn't had a chance to introduce themselves? All right, wonderful, thanks. Ms. Meserve, I see you have something to say, please.
Sorry, I was raising my hand actually, Ocean Reserve for County of San Joaquin, and then it kept going away. So, anyway, just with respect to the idea of setting groupings, and ordering at this conference, my feeling is that that is pretty premature right now, as we haven't.
And I'm sorry, I
So-
don't mean to imply that we would
Okay.
set orderings or groupings. All I meant was we'll set a deadline for all of you to submit your proposals as to what those might be today. So today would be just coming up with when is an appropriate deadline to come back and say, this is what we tentatively worked out. I want to give you enough time to have those conversations and be mindful that there are a lot of deadlines coming at us really fast. So that's why we talk about have the deadline, the discussion about that issue and how fast these deadlines are coming at us before we attempt to set a deadline for this additional task.
Yeah, one thing that I have seen in a hearing that was large like this, that was before the board or the designated hearing officers, was we had more of a rolling submittal of case in chief evidence. And then, but, you know, so that not everybody had to submit it at the same time. It was more keyed to the ordering, so I think it's important to talk about the ordering. And then proposals for groupings came after that. So because I don't think it could be assumed that everyone who is a protestant who intends to submit evidence has already or will be able to in the next, 30, 40, 50, 60 days, do that kind of coordination. So it really helps us to see what the other folks have submitted. And then we can communicate with them about maybe doing some groupings. So just to kind of put that idea out there. Thank you.
Thank you. That's helpful. All right, we'll turn back to this issue, and I think it's about to come up with respect to whether we should change any of the deadlines for the hearing, but I'm going to pause here. I ran through my specific questions before we jump into the questions I identified in the hearing notice. Are there any other procedural questions that any of you have at this time? You will have other chances in this conference, but anything that I can clarify or that you think we should address before we move into the questions that I raised in the hearing notice? All right, then I'll turn to question 1, which is whether the hearing officer should change. Oh, no, let me pause. I think Mr. Hitchings, I have a note here. I don't know if we want to talk about this now or later, but I believe the authority asked for deadlines for evidentiary objections. Is my note correct? Or maybe maybe
yes,
did I misattribute that request?
I think just to ensure that there'd be a process in place for that, our familiarity with other AHO proceedings is the hearing officer would accommodate evidentiary objections depending upon the phase or the submittal of testimony and rulings on those. So that was really what we were raising, not by a certain deadline, but as different evidence or different portions of whether it's direct, case in chief, or rebuttal, that there'd be opportunities for objections and rulings by the hearing officer. And I think you did touch on that earlier as far as some of the procedural actions you would take.
Okay. Thank you, Mr. Hitchings. So I'll turn back to question 1. Should the hearing officer change any of the deadlines or hearing dates listed in this notice or make other changes to the hearing schedule? I have a number of notes down. I will turn to all of you to have a chance to comment on this. I think, well, first of all, we've already brought this up, but I wanted to acknowledge the overlapping deadlines with the Delta Conveyance Project process and the Bay Delta planning processes. I do realize that April 29th is an overlap. It's something that we are going to be mindful of as we move forward and try to avoid if at all possible. So that's something, just a renewed awareness of something on our end that we need to do as a board. And the board staff is look at all of our deadlines across the different our different groups here. So we are committed to looking at these. I saw the request. I mean, there are a number of requests to postpone this proceeding until after the Bay Delta planning process. If not that, alternative requests to extend the deadlines for everything by 45 days. That's something I think I'm not going to decide that today, but that's something that I think should be seriously considered, and we do plan to seriously consider it. Then there are these issues with the operations plan for Sites Reservoir, the incidental take permit. And I want to talk about that. I want to turn to Sites and ask some more questions about about those documents and when we might see them. So first I will, Ms. Mandel-Rice, if you would like to chime in, but I think my next step is to turn to the authority and ask for more clarification about the operations plan and the incidental take permit. All of you will have a chance to chime in on this issue explicitly, but I was thinking of starting there, but Ms. Mandel-Rice, please.
And I don't mean to derail your conversation. I think it's just really a question. You're clearly dealing with kind of a bigger picture issue here. With respect to this question about whether any of the hearing dates should be moved, more specifically, if there are dates that there are irreconcilable conflicts with, is there a best practice in terms of informing you of when those conflicts would be? I'm mindful of the number of parties on here today that likely have this issue.
Thank you. That's very helpful. Please submit them in writing to the Sites Reservoir email inbox. Please do CC the service list.
Will do. Thank you.
All of you will get a lot of emails about this proceeding, and it's unavoidable. But please, that would be if there are irreconcilable conflicts. And I also acknowledge we haven't even started talking about witnesses and their availability and that kind of thing. This will come up, and we will try to make this process as efficient as possible and as workable for everyone. With the caveat that there are a lot of people involved. On that note, so we're all clear and we all have personal lives, you may notice the hearing schedule as currently proposed essentially blocks out late July, early August. I'm planning a vacation. So if you want to plan a vacation too, I'm not going to, there will not be surprise hearing days in that time block. So I wanted to make that commitment, that we're not going to send out a new schedule that says different things. Just wanted to be, we're going to spend a lot of time together, so I want to be as transparent as possible. So I'll turn to the authority. There's this question of an operations plan and the incidental take permit. They're related but separate. I guess my first question is, there was some discussion, I think, by the submittal by CSPA and Friends of the River, and then some others about, what I think was a draft operations plan that may be coming. It wasn't quite clear to me whether it really is coming, what it is, and in your opinion, how important that might be to this proceeding. So I'll start with the authority. Mr. Hitchings, do you have comments on this, what is being referred to as an operations plan?
Yeah, thank you. Actually, I'd like to.
You must have something else is, yeah. Do you have two devices going?
Yeah, I apologize for the echo.
There we go.
Aaron Ferguson on behalf of the authority. And with respect to the operations plan comments, I just want to, pardon me, stop an echo.
I'll do it.
Mr. Hitchings and I are in the same room.
That's the problem. One of you has to, yeah.
Okay. Can you mute?
They're just mute. Apologize.
Does that sound better?
Yes. Now you're clear.
Yeah, there's an issue, I think, with one of the microphones. So sorry for that. Apologize. Yeah, I think on the operations plan, most of the objections that were raised, I think, were more with regard to kind of the release schedules and how water would be provided to sites participants. And our position is that from a water rights application and for release of priority and petition for assignment, those issues aren't really have an impact on the water rights determinations and the findings that the hearing officer and board would make. So to the extent that an operations plan becomes available, obviously that's going to be a public document when it is available, but it is not formulated completely at this time. There have been, various efforts to complete that, but overall, our position is that that's not a necessity to have as part of the evidentiary record for the purposes of a decision on the application and the petitions. On a couple other points that I think you raised in the overall questions was with regard to the ITP. We did propose in our pre-hearing conference statement a limited, I'll just call it kind of a reopener to the extent that the other hearing aspects are concluded or we're still in the midst of them, that there'd be the opportunity to provide that through a additional submittal, the notice of the ITP, the submittal of evidence, and the ability to have cross-examination on that. And that's detailed in our pre-hearing conference statement. Overall, the overall schedule, the authority obviously would like to keep with the schedule. We are fine with how it's been laid out at this point. There are always issues within California Water where we have overlapping processes of large projects and large regulatory proceedings, and I don't believe that's going to change whether it's 6 months from now or a year from now. We did file our application in May of 2022, and we're now 2 years from that. So we think it's reasonable, the schedule that's been set forth by the hearing office, and we appreciate that schedule and would really like that to be the schedule going forward. But I know your main question was on the operations plan, so I wanted to at least provide our detail and position on that. Thank you.
Thank you. And I'm going to ask you to stay off mute because I just wanted to ask some follow-up. I want to make sure I understand, and this is addressed in your pre-hearing conference, and of course you'll have many chances to address it in the proceeding. But in terms of the release schedule, I mean, to some extent, this is getting into substance, but I think it's necessary to talk about process here. I can imagine, just in very general terms, a water rights injury issue if you're making releases and then and that water is being down the Sacramento, and that water is being picked up downstream. There would have to be some discussion of conveyance loss, things like that, how that accounting would take place. But I think, is it the authority's position that the operations plan itself is not necessary for that type of evidence to come into the record and for the board to make a determination about potential injury?
Yes, that is our position, and also the CEQA document that's been certified and approved covers the totality of the releases and potential impacts associated with them.
So the CEQA document encompasses any potential operations that would come out in this operations plan.
Well, certainly with regard to the release schedule.
Right.
And one of the reasons that Ms. Forsyth is on this, if there were technical questions like that as well, she's available and can provide any detail that she might have, but I think that's generally the position that the authority has.
Thank you. I appreciate that. And then you gave a general response. So one of the things, just being perfectly frank, that concerns me is that this draft operation plan is going to come out in, I don't know, September. And then we're partway through the hearing, and then someone in the proceeding, whether it's the authority or someone else, is going to want to submit it as evidence. And then we're going to have to offer an opportunity to respond. And we're going to, it doesn't make sense to just wait until we have this document, even if it's not necessary for the board's decision, because we know it's coming. And it may be less efficient for us to charge forward and then have to circle back and do a lot of sir rebuttal and sir rebuttal and whatever the words are. So I'm being perfectly straight, and I'm just setting this up for you to be able to respond to that comment. Do you have any, first of all, I'm not asking for a commitment, but guesstimate of when a draft operation plan may become public? Well, and do you have any comments on how that might impact this proceeding?
I mean, our current estimate, it could be the end of June, early July timeframe. But that's at this point kind of the goal, and hopefully we can meet that. But I still think from an efficiency standpoint, you know, that's one element. To the extent that it would bear on some of the issues, I think the hearing process could accommodate that. But it doesn't warrant delaying the overall start of the hearing because of that one element.
And then this operation plan, it's something that's being negotiated in part with the Bureau and the Department of Water Resources. Do I understand that correctly?
That is correct.
Thank you, Mr. Hitchings. I will turn to Mr. King. I see that you have a comment on this.
Yeah, so I agree with Mr. Hitchens that we really want to keep on moving forward for the efficiency, keep on going forward, but also acknowledge the complexity of all the issues before us. So I believe the operations plan is material because it really affects the timings of release, both north of Delta and south of Delta. And realization, acknowledging that over a majority of the participants are local participants, and how that may impact how their economic incentive to make north of Delta and south of Delta deliveries might impact the area of origins concerns, and then the other issues regarding where the appropriate environmental flows may be and the timing of those. I think that's all interrelated. So I see a lot of area of ordinance issues just because there's going to be economic incentive of people transferring water, their water rights as participants out of the county, which would mean that we'll definitely have impact on permanent crop plantings and other planting, especially during critically dry years. Also incentive to pump degraded groundwater, and just a lot of complexity with that. So I know I'm getting into the weeds here, but I would just like to say, I look at this proceeding sort of as a proceeding in equity, and that you're going to look at all the facts and circumstances, but at the same time, I want to acknowledge that this is a very important project, and there's a lot of money being spent, and there's a lot of interest rate risk in completing the project. But I want to have it where this process can reserve issues that may come up, because there's bound to be more information that materializes as we go through. Hopefully that makes sense. But I think the area of ordinance issues are important, and then how the economic incentive for people to actually get a project going and getting economic return on that, and especially when you have a majority of the interest in local, we could have some disincentives for long-term sustainability and material impact to area of origin concerns that are part of our law and the water code.
Thank you, Mr. King. I want to follow up on that just to make sure I'm following you correctly. I think I understand your comments certainly with respect to diversions by the authority. I wanted to follow up on specifically with respect to the operations plan, which, as I understand, is mostly focused on, or would mostly be focused on, releases from the reservoir and what happens with the water after it's released from site's reservoir, and the timing of those releases and that kind of thing. Can you connect for me those issues with what you raised about area of origin and
so it really, from what I've seen with the documents around this entity called the Colusa County Flood Control and Water Conservation District, there's a Zone 3 has been established, and it comprises about 78 different landowners who are participants. The cost of that water is prohibitive for the use for permanent plantings, and it's also anticipated that there will be an annexation into Yolo County, which goes beyond the current district, which is solely Colusa County. So there's already in works economic incentive to export water out of county. And that's just the reality of it, and just going to increase as time goes, as interest rates increase. So that's what I'm really, focusing on. Is this project's been in the works for many decades, and a lot of people have economic incentive to make it happen, especially locally. And their economic incentives may be in contravention to the intention of the legislature when they adopted the ordinance laws, but also specific legislation regarding the sustainability of the Colusa Basin and Colusa County as a whole. So hopefully that makes sense to you.
Yes, thank you. That's very helpful. I understand, I believe. Thank you very much.
Okay.
I think Dr. Curdy was next, so I will turn to Dr. Curdy and then Mr. Mooney.
All right, thank you, Nicole. Something the record needs to be somewhat corrected from what Mr. Hitchings said. The CEQA document absolutely does not account for the impacts or the concerns of the Colusa tribe. This is a matter of public record. Not only when the water will be released, but the very capture of the water and the significant environmental impacts, impacts on the human environment, on the environmental setting, on the health and well-being, on the cultural practices, and the identities of the people of Colusa are going to be significantly, irrevocably impacted. And there has not been due consideration of that. And that's no fault of the tribe. That's how this process has unfolded to date. So that's fundamental to consider here. It's fundamental to consider when we hear statements like sustainability. What does sustainability mean for the tribe? It does not necessarily mean sustainability through these common notions of the 3 pillars of sustainability of humans and environment, economics, and then what's privileged within that. So even when we're talking about economic efficiency, we have to see, is that efficiency itself dependent on a sacrifice zone, as it has for so long been on native cultural landscapes and traditional practices and the health and well-being of the people of Colusa and other affiliated tribes. So that's a fundamentally important corrective. The CEQA document does not account for that. And the Sites Project Authority themselves on the public record said, oh, well, you still have the Section 106 process. So the Section 106 process on the federal level, we know is meant to accomplish something different than the NEPA process. And let's be clear, when the Bureau of Reclamation did their scoping, that was 2001. It's a much different time now, including around tribal rights, around tribal capacities to be able to take part in these processes. We have to consider the larger systemic context of what has been occurring. So even though we make the statement that, oh, this project's going on for decades, the people of Colusa have been here since time immemorial, and to date have not gotten their perspectives, their relationships, what these impacts will be on their traditional cultural practices, on their identities, on their health and well-being, and on their capacities for collective continuance as a people. So that's something I think that's very, very important when we're considering this within the state context, both with Governor Newsom's executive order N-1519, which recognized the attempted genocide of the people of California, and ongoing cultural genocide, which is a diminishment, whether wittingly or unwittingly, on purpose or not on purpose, of people's capacities and relationships to these resources, including water. Not to mention the water rights of the tribe, the federally adjudicated water rights, how those will be impacted to date have not been given appropriate consideration or attention. Thank you.
Thank you, Dr. Curdy. Let's see, a couple of, I fully anticipate that there is going to be disagreement about the applicability of the findings in the CEQA document. And that's something that will come up in this proceeding, and there certainly will be room for discussion about that. The board's authority and sources of authority extend beyond CEQA. So this is not a proceeding focused on, I mean, the CEQA document is quite important and relevant, but the board's authority is separate and apart from that granted to it under CEQA. So that's understood. I think everything you raised, from my perspective sitting here today, seems should be a space for all of this within this proceeding, and there is a space within this proceeding for that. So I am very pleased that there is some representation of the tribal interests here today, and that it looks like we may get that in this hearing because that would be a deficit. If we didn't have that element here, we would not have a complete record. So I just wanted to make those comments in response and acknowledge what I anticipate will be disagreement about the secret document. Of course there is. There always is. Mr. Mooney.
Thank you. Well, we kind of set forth our concerns in our about the lack of an operations plan in our pre-conference statement. A couple things though I want to elaborate on and point out is that Mr. Hitchings has talked about that the CEQA document and the EIR identifies a lot of the impacts. But one of the issues would be to make sure that the operations plan is actually consistent with the EIR and the determinations of the EIR. If we if part of the operations agreement, as was discussed, includes the negotiations with the Bureau and DWR and project partners, and how they're going to release water, how they're going to take water and use water, we would want to make sure all of those aspects of those agreements as well are consistent with the CEQA document. And it just seemed if, the authorities had lots of time to put together an operations plan and to tell the protestants that we're not going to release the operations plan until well into this hearing process, until after the time for the preparation of the written testimony.
I've been over here to this corner.
Mr. Porgens, you appear to be off of mute. Thank you.
So you're off of mute.
Now you're off of mute again. Thank you.
So we think it's critical. I mean, it's critical information for my clients to have in order to be able to even form their case in chief to determine whether or not it's consistent with the environmental document. And Mr. Hitchings had commented about that it was he doesn't think it's necessary for a determination with regards to water rights. Well, we think it's essential for the board's determination with regards to environmental impacts. And as the hearing officer indicated, the board's role goes above and beyond or is independent of CEQA. So we also think that it's absolutely critical for the board to know exactly how they intend to operate, how they intend to operate with reclamation, how reclamation intends to operate in conjunction with its other facilities, and if it's going to have any impact on those. So just and to say, well, it gets opened up if we end up not having it until July, August, September, are we going to open up to have case in chief again on just the operations plan and go back and kind of redo all this? It's especially if it needs to be part of the record, the evidence in this record, and if it is, we have to have adequate time to review it, adequate time to see if we need to find additional witnesses to address any issues that have been raised by the operations plan, and to prepare that written testimony. And that just can't happen if they release it on Tuesday and say, we have 2 weeks or we have a week. Again, they've had lots of opportunity to prepare this. They've known the hearing. They've known that the hearing notice was released on March 1st. We could have had it by now, if they wanted to get it to us. So, but again, we believe it's critical for the board's process, but it's also critical for our ability to adequately participate in the hearing.
Thank you, Mr. Mooney. My intent is to go to you, Mr. Ferguson, and then I think we should take a brief break so that I can get another cup of coffee, if that sounds good to you, unless you would prefer to speak after the break.
I can speak now.
Okay, thank you.
Yeah, thank you. I just want to clarify one thing. There are two different plans. One is an internal operations plan that Sites is preparing that deals with its diversions and releases. The other is an operations agreement that the sites is working on with DWR and Reclamation that deals with coordination issues. So the operations plan that we're addressing now is site's internal operations plan. That plan must be consistent with the EIR. The plan will simply take the operational parameters that are in the EIR and put it all into one spot. And since those details are in the EIRs, in sites' case in chief, it'll be prepared to present operational details that folks are free to cross-examine the authority on. They're free to present rebuttal witnesses on. And so there will be an opportunity for folks to address those operational details that sites is proposing and will include in its testimony. And there's no need to wait for a document that puts all those details into one location.
Thank you, Mr. Ferguson. Just a follow-up as I'm trying to think through these issues. I think Mr. King raised the point about export, and as I understand it, exports and how much of the water would be expected to remain within the county or neighboring counties, and then how much may end up being exported. Is that estimate something that either is in the CEQA doc, in the EIR, that would be expected to be in the operations plan, or is something that is something that's just not known at this point? It's something that would be developed later and over time.
Yeah, those sort of delivery assumptions are in the EIR. Each participant in sites, the investors, have a certain storage allocation, and they will be able to call on water that's available within the reservoir based on that allocation according to certain operational parameters. And so in that regard, yeah, those details about the water that could potentially flow to the Sacramento Valley are contemplated, and then as well as the water that could potentially flow to members that will ultimately get their water through export facilities in the South Delta.
Thank you, Mr. Ferguson. That's helpful. All right, it's 10:32. I'd like to go ahead and take and it looks like we're going to go through lunch, so you plan on coming back after lunch. I have a feeling this is extremely helpful, so thank you for your time. But it's 10:32 still. Let's take 20 minutes and come back at 10:52. I remind all of you to please go on mute unless you want others to hear your conversations here. So please go on mute. You may turn off your cameras, but I will see you at 10:52. Thank you.
Good morning, early birds.
Welcome back, everyone. It's 10:54. I'm slightly tardy. I apologize. Let's go ahead and pick up where we left off was discussion of the timing of this proceeding and both the operations plan. And I also wanted to raise the ITP as well and the timing of that and incorporate that into our discussion so we don't have to necessarily go around the room again. So please feel free to comment on both of those interactions. And I don't know the order of things, so I'm just going to go in the order, and maybe this is the time chronological order, but the ordering on my Zoom screen. So I will turn to you, Mr. Boucher. Please go ahead.
Thank you, Hearing Officer Kinsey. Just three quick points for the San Francisco Baykeeper protest group on these issues. First, on the substance of the operations plan and coordination between the Bureau and DWR, the plans to do that. Sites has represented and has very publicly thought about and considered how the releases from the reservoir may be used in ways that would benefit the environment or to mitigate the harm that the diversions from the Sacramento River are going to cause. And so we think that the operations plan, in assessing whether this is in the public interest, what are the consequences for fish and wildlife going to be, is a necessary piece to putting together the case in chief evidence that relates to the project as a whole. Second, just as a process matter, and I think this is true for both the operations plan and the ITP, setting up a process by which we are ensuring that relevant evidence that the parties are going to want to consider comes in after we've all exchanged case in chief evidence, after we've started the cross-examination process, makes certain that the amount of time we are all going to spend together is much longer than it has to be, because we're going to have to come back to say, okay, these 6 entities have already done case in chief and cross-examination, but now we've got the operations agreement, they get to weigh in. And then we're going to come back in October and November and say, everybody's already done presentation. Now we've got the ITP. Everybody gets to weigh in on that. Or we're going to exclude relevant evidence from the expert agencies. Those are the only two choices. And so just process-wise, we should make sure that we have all of the information that's going to be relevant and necessary before we start the evidentiary proceedings. And then third, overall, I want to echo the comments of Ms. Meserve, especially, and others who have requested this. The overlapping adjudications and litigation and regulatory proceedings related to the water quality control plan, to long-term operations of the Central Valley Project, to the Delta Conveyance Project, to this proceeding, put significant burdens on public interest organizations and others that have limited constraints and significant mission-driven concerns about this project. And I appreciate your comments at the beginning that the board and staff are trying to take into account those overlapping deadlines and priorities. But it's really important for our organizations and for the protestants, especially many of them, to be able to participate in all of those things. And it's really difficult to do that when we've got LTO plan at the beginning of July, sites hearings in July and August, Delta conveyance proceedings ongoing, a program of implementation draft expected this summer. And all of those things provide regulatory backdrop and constraints for the project as a whole. And we think that the more time we spend being patient at the outset, making sure that all of the information is in place, the more efficient and more fair the proceeding will ultimately be when it occurs.
Thank you. All of your points are well taken, and I don't disagree with you by any means in terms of your points about having to circle back if evidence comes in partway through the proceeding. So thank you for your comments there. All of it. I see, so I'll just check off the list so you know what's coming. I see Mr. Spain, and then Ms. Meserve, and then Mr. Porgens. Mr. Spain, please.
Thank you, Hearing Officer Kinsey. I want to underscore, well, first off, we are commercial fishing organizations, so salmon harvests are our livelihoods. We have a major interest in what happens to salmon in the California Central Valley. This will have quite an impact, but we can't ascertain what that impact is unless we know what the operations plan is. Without an operations plan, we don't know the timing of releases. We don't know the volume of releases. We don't therefore know the temperature of the releases. We don't have any of the constraints that affect salmon before us to judge on any basis what the ultimate impacts will be on our fisheries and on our not only the fall Chinook, but the ESA listed stocks that are also there intermingling with all of these. The other thing is that, and so I agree with Mr. Mooney and Mr. Busher that the timing is inappropriate. It's not a long gap to the point where we'll have hopefully at least a draft operations plan. The project proponents are working to get that out, but it needs to be on the table before we can really constructively ascertain what, if any, fish benefits there are here. We've been promised benefits, but it's always been vague, always in the future. We don't have any idea without an operations plan. The other thing is the roadmap here on the incidental take permit is going to change very soon. As Mr. Busher pointed out, the LTO process is going through the reconsultation on the 2019 BIOP is that the current Biden administration is not defending. They're reconsulting on that. Sometime late summer, we will have a very different roadmap for the incidental take permits and for whatever protections are necessary for ESA listed stocks within the California Central Valley Project. That also will impact the operations plan. It will impact whatever incidental take permits the state issues. All of that will be considered and changing rapidly sometime midsummer, maybe late summer at most. So again, we believe also that it's premature to move forward on a lot of what we're dealing with until we have those things in the pinned down at least somewhat. And we're not talking about years, we're talking about weeks to months at most.
Thank you, Mr. Spain. Ms. Meserve.
Thank you, Ocean Reserve for San Joaquin County. And I believe Mr. Ruiz, we're kind of tag teaming some of the same grouping of issues, but with respect to the agreements that have been referenced that are forthcoming, I agree that the site's internal operation plan sounds very important for the reasons that have been previously stated by others. With respect to the MOU with the Bureau and DWR, I think from a in Delta perspective, in addition to the releases, we're also very concerned about how decisions will be made about whether to place water in storage, when and whether to place water in storage during its diversion season, and how that might affect storage in the upstream reservoirs operated by the Bureau and DWR. And in particular, how that might lead to the ability of the state and the federal water projects to meet water quality standards, particularly in a long-term drought, like a 5-year drought. So, you know, I get that there's, you know, at some point this application and the hearing needs to take place, and it shouldn't be never. By the same token, you know, I've been working with very small water rights applications that have been going on for years that have like kind of zero potential to affect the watershed that have been slow walked for various reasons at the state board. So I don't, you know, I feel a sense of unfairness, honestly, in terms of the small farmers I've been trying to represent to do wintertime storage projects and our ability to get somewhere. So anyway, that's a sidebar. But so yeah, there's this issue of the and so I don't know enough about the MOU with DWR and the Bureau that's referenced in the state water contractors protest and in their update to know. I think if it could be confirmed that that has no effect whatsoever on kind of the end of year storage amounts relative between sites and the other reservoirs, you know, maybe part of my concern on that could be addressed. But I think, you know, we're very concerned about whether, and also another complicating factor is that the Bureau and DWR are participants in sites. So we're concerned that whereas water that would be placed in storage in the CVP and SWP reservoirs is subject to requirements to meet water quality standards for the Bay Delta, that the sites may not be subject to those same standards right now. And we had worked on trying to address that in the settlement period and got, you know, somewhere along there in the discussions. And I appreciate the willingness of the sites folks to you know, entertain that, but there is a larger issue when it comes to long-term storage. And then with respect to area of origin, I think, you know, the county and others in the Delta are very respectful of area of origin. We do see the allocations of storage, and we are very sensitive to making sure to preserve the priority of those types of rights. The way I added it up from the table that was available in the participation summary, that was about 14% of the overall storage. So overall, maybe a small portion of this. The rest of this would be for export and shouldn't be afforded those kind of priorities. Last point is with respect to the ITP, I was a little surprised and didn't have a chance to respond to the sites hearing, the sites groupings response on the ITP and the idea that the water board shouldn't be able to put any conditions on the permit that relate to protection of fish and wildlife. And I think that in particular, that points to the need to have that permit in place before, you know, I think we do have fisheries concerns in the Delta as well, because that impacts how the water's managed. So, you know, we're not necessarily the prime movers on protecting fisheries, but we are very concerned about what's happening with our salmon and all the fisheries and the unlisted fish like fall run, for instance. So if the Sites Authority is saying like, oh, the water board has no authority on this issue, then definitely we would need to see what Fish and Wildlife is suggesting or requiring in the ITP as part of the application that we would respond to in our case in chief. And I think, so with that, I would just say, yeah, I think that we need to have an orderly hearing, having participated in a tunnel hearing. It could have been more orderly maybe, and a lot of the problems that stem from that, and I think water board staff consulted with DWR about this afterward, was that it was hurried through when some key issues about what the project was and what it was proposing to do were not there. And so it just led to a lot of problems. So I know you've got a difficult job to try to wrangle all this, but those are my comments. Thank you.
Thank you, Ms. Meserve. I appreciate it. I am going to exercise my discretion here and ask Mr. Reese if you would cut in line and go next. I will get to you, Mr. Porgens, but it sounds like there's some alignment here. So if you would, please, Mr. Reese, feel free.
Thank you, and I'll try to be brief and not repeat most of what Ms. Meserve indicated, because we do, the Central Delta joins in that position. With regard to the overall concern with the operations plans, it seems like the authority has had ample time to come up with something that can at least have a publicly releasable document. And that's what we really are looking for before this process begins. As Ms. Meserve indicated with regard to the water fix hearings, that hearing became so backloaded with rebuttal and surrebuttal that the initial case in chief almost became, I wouldn't say moot, but almost irrelevant. So I think it's very inefficient if we end up having to backload the substantive issues to rebuttal and surrebuttal. And I think we should wait until we have some sort of operations plan that at least provides some direction. And if the plan is supposedly going to be available in June or July, that's not a real long additional delay. Thank you.
Thank you. Mr. Porgens, I will turn to you. And I may have caught you by surprise.
Oh, can you hear me?
Yes.
Okay. First of all, thanks for acknowledging me. I just had time to have breakfast. At any rate, I'm going back to the fundamental issue here, what has to do with the operational plan and the coordination plan with the Bureau and the Department of Water Resources. And by the gentleman that's representing the site's project, he said he could probably have that somewhere in July or August, right? That's what he said. I recorded that. And so if you look at that, that gives him more than 45 days, to get his plan to us. I don't think it's wise to take one step forward and 2 steps back, because as has been brought up by a number of the protestants, we have a situation here where we have limited resources. And I can appreciate sites' drive to get this project operational. However, we can't know it's operational until we have the operational plan. That's just common sense. So getting back to this project has far-reaching implications because it affects the counties and areas of origin, which there was only 4 cases that I know of, and I just completed a report on it, where this whole issue has been brought up before the courts. And it wasn't that favorable for the counties and areas of origin. So what I'm saying here is that I worked on the Glen Complex, which was this is a new rendition of the Glen Complex, which was a project that was being proposed by the Department of Water Resources back in the 1970s. And when they're talking about releasing water and trying to mitigate for fisheries impacts, we have to keep in mind that on several occasions, we had 95 to 97% mortality rates on the Sacramento River by the Bureau and the department. That's a significant loss. And I told them in advance they were not going to be able to meet it because the water was going to be too warm. Now, if you look at the evaporation rates over there in that particular region, And the last I checked, which has been a while, I'll have to go back and look, but it's 120 and above, 120 inches of evaporation a year. We're going to have hot water, warm water that's going to be, we're going to use that to mitigate for the flow requirements, for the fisheries. I'm at a point now, I've been waiting for 64 years for the board to come up with a plan that's going to protect the Delta, which they haven't done. So I'm involved in all of these proceedings, and it's costing me a lot of money, time, and my health. I don't have the bankroll that these people have, but I'm a public interest person. That's all I'm here for. And I'm saying that if these people want to push this program ahead, where it's going to cause complications later, it's going to be doing a disservice, not only to themselves, but to everyone involved in this process. So I'm saying that we're still waiting for the San Joaquin voluntary agreement. We haven't come up here in the North Sea yet to get on allocating who's going to provide how much water from the various diverters in the Sacramento River to meet the Bay Delta water quality standards, because that's presently on the shoulders of DWR and the Bureau. So what I'm talking about here today is they're only waiting 2 years. We've been waiting decades. So, and I'm trying to be fair here, okay? I'm not opposing their project in that one sense. If that's something that could be done, and they can prove that it can be done, well, then I'll have a different position. But at this point, there's insufficient information, and they're pushing it too far, too fast. I suggest, as has been suggested by others, knock it back 45 days and have them give us what they're required to give us. So this way, then we can all be on the same page. That's all I'm asking for. And if they can't do that, then I have to question their motives. So that's all I have to say at this point in time. I have to go relax now, okay? So,
Thank you, Morgan.
Yeah, you're welcome. Thank you also.
Thank you. I'm going to read off the list on my Zoom here. I have Ms. Chigazola, and please correct my pronunciation, and then Mr. Ornbaum, Mr. Mooney, and then Mr. Ferguson.
Hello, thank you, Regina Chicazola with Save California Salmon. I just wanted to bring up, we've been asking for an operations plan now for over 5 years. So this isn't something that's like just come up. We've actually commented on every reiteration of the EIR that we need an operations plan to understand the impacts. I live on the Trinity River. We represent a lot of people in the upper parts of the watershed closer to Red Bluff, including fishing interest and ocean fishing and interest and tribal communities. And we've asked for these things a lot of times. We've asked for an assessment of what the diversions, taking out of the diversion at Red Bluff means when the water won't be put back in for the environment until Knight's Landing area. So what does that mean for fisheries? What does that mean for spring salmon? Something that's changed a lot since this started, which is why I feel like looking at the incidental take permit is going to be really important, is a lot of the water that is targeted through this water right, which is for, even though it's taken at Red Bluff, is for more east side tributaries as far as what's unallocated for, are the same tributaries where there's now an extinction crisis for spring salmon right now. And spring salmon are very much impacted by changes of flows and flow releases. Some of the biggest issues for spring salmon are actually the interbreeding between fall salmon and spring salmon that happen because of changes of releases in certain times of years, and that's often for conveyance. So I feel like these issues are critical. Like, I've been wanting to get a better understanding of what this is going to mean for now 5 years and asking for this operations plan, because we're trying to tell our communities what it means in other areas of origin for these diversions, and we can't because we don't have an operations plan. We've seen fisheries agencies over and over again reject that this is going to be beneficial to fish and wildlife, and which is important for not just the public trust, but also tribal trust. And it is a responsibility of the board to protect these. And in the end, maybe the operations plan will show the impacts aren't as severe as what we expected. And maybe the incidental take permit will show that too. But to be able to argue without seeing those things makes it very difficult for us to argue for our communities and for the protection of beneficial uses. We need to see what the flow releases look like, see what the diversions look like. We need to see the impact for that stretch of river between the diversion and the releases. You know, how will it impact water quality, selenium, things of that not selenium, salinity, and things of that nature if we don't have an operations plan, an ITP. And because the timeline is short on these things, and what Glenn said before about the new biological opinion coming out, it's important. And for anyone to say that the Delta Conveyance and Sites project are not like related as far as operations and don't interplay with operations as far as the new biological opinion, like that's impossible. Like all these things are so interrelated, and operations will also show us what water from the Bureau is being stored. You know, there's a lot of assertions within the documents. You know, the first iteration of the EIR said that this was going to have some pretty heavy impacts to fisheries during good years, you know, and those good years are getting rarer. And they're kind of all we have left as far as for the fishing community to be able to fish. So I think the operations plan and the incidental take permit will show whether or not that's still an impact. I mean, there's so many assertions that it's not, but we kind of need the sites to put their money where their mouth is. We need to see the impacts. This is a private reservoir. So once it's built, once the water rights is approved, we have less control over the storage issues, over the impacts than we would for, say, Trinity or Shasta or some of the other reservoirs that the state has more control over. So I just think it's really critically important for us to be able to argue that we know the impacts. And so I'll just leave it there because I don't want to repeat things that PCFFA or Baykeeper said, but I just wanted to echo. And also, as far as capacity, we only have 2 people that work in the policy arena at Save California Salmon, and we work throughout the entire state. And we do represent, you know, tribal and fishing interests throughout the entire state. So having to go through 2 water rights hearings, a biological opinion, and a water quality control plan that are all connected at once is hard capacity-wise. It would be much easier to see a couple, the operations plan, the incidental take permit, and then have the new biological assessment come out to be able to really fully engage in this process. So thank you so much.
Thank you. I appreciate your comments. Mr. Ornbaum.
Yes, thank you.
Thank you.
I'd like to go back to right before break. You know, we were talking about operations, and some of the last statements were that the participants in sites, you know, have the right to allocate, you know, or send their water, you know, as they see fit. It's their investment. The problem I have with that is that I know most all the local investment in Colusa County, and I personally talked to them, and they will export and sell that water.
That's right.
That's point of origin water that's leaving our county. They will export and sell our water because they need to in order to pay for the investment, and that water will be gone.
Thank you, Mr. Ornbaum. Did you?
Can you hear me there? I lost you.
There you are. Okay.
I don't know how much you got of that. The participants have the right to allocate their water as they see fit, you know, in the investors and sites. Trouble I have with that, the point of origin water, the Colusa County water, will be allocated to all the investors. And even the local investors, that water won't go on the surface in Colusa County. That's a false narrative. Because of the cost is so high to build this reservoir, that water will be sold for 30 to 40 years outside of our county. So, and that's just a fact that people don't talk about. So the last statement before break was saying that the allocation, you know, will go out to the investors, but our point of origin water is not protected. Our point of origin water, if that right's given to outside investors, which I don't believe it should be, and even our in-county investors, that water will leave our county and become a profit center, and our county will be dried up for 30 or 40 years. That water will not be wet on our county. I don't know if that's understood by people.
Thank you, Mr. Ornbound. And that is an issue that's related to the public interest that's within the scope of this proceeding. So it's certainly something that I encourage you to raise and present evidence on, so that it's part
I have. I'll continue to do so. When we're talking about operations, they were saying that was, the investor decided where the water goes. Well, all that water from our point of origin will leave our county.
And my point about the record here, I just want to be clear to make sure, especially for those who may not be attorneys, we're developing an administrative record that will be the universe, if you will, of what is considered by the board. So it's important, although many of you may have raised these issues again and again with the board, it is important in this process, and part of my role here is to gather that evidence through this proceeding, submitting evidence through case in chief, getting that testimony and through cross-examination, and getting in the record so that the board can consider that when making this determination. If it's not in our record, it can't be considered. So I just want to be very clear about the process here.
So it's not in our record as a written statement, you mean, or even
well, your written statement, any written statement that has come into this proceeding so far will remain there. I just meant that if you've made comments to the board in the past before this proceeding began, that isn't necessarily in our record. So what will be important is to present testimony and evidence through this process so that we have it here for consideration in this process.
Great. That's my testimony then. So yeah, the point of origin water should not leave our county.
Well, we're not testifying. And here's another point of clarification. We're not testifying today. This is a procedural discussion. So your statements today are certainly being considered as a matter of policy, but not as a matter of evidence. The time for your testimony to come in will be through case in chief and through rebuttal, and then all the parties will have an opportunity, if it's your own testimony, to cross-examine on the content of that testimony. So what we're talking about today is procedural. It's like I said, I'm certainly considering it and the relevance to these procedural decisions that we're having to make as we go forward. But the hearing itself is where the evidence that the substantive decisions will be made that are based upon that evidence will come in through the hearing process. And at that point, I will ask you to take an oath and swear to the truth of your testimony and such through a formal process.
Okay, thank you.
Thank you. Mr. Mooney.
Thank you. I know I've already spoken here, but I just wanted to briefly respond to the comments by Mr. Ferguson, and I'll keep it brief. When we wrote our pre-hearing statement, we were under the assumption that there was one operations plan, and that it included agreements with Reclamation, DWR, and whoever else is necessary. I just want to make it clear that if our position is that we really need those agreements, whether it be in addition to their internal operations plan, we really need those agreements as well, as I think Ms. Meserve had indicated the reasons for, because we need to know the obligations, the commitments of these entities, and when that water is going to be delivered, how they're going to use it, how it might impact other entities or other facilities. So again, I just wanted to reiterate that our comments should be not just an operations plan if there's these separate agreements. And then I'd also state that it would seem to me that their internal operations plan should be taking into consideration the agreements with Reclamation and DWR and how the system's going to operate and the deliveries and such. So it seems if there's not just one operation plan that includes all of that, it certainly seems that there should be. But we need both. We need all of those documents, and really, we believe, in order to proceed with the case in chief on this and have adequate time to review them and prepare. So.
Thank you. Understood, Mr. Mooney. I'm once again going to exercise my discretion here and ask Mr. Bussey to speak first, and then Mr. Ferguson, you can wrap, as it were, on this. So, Mr. Bussey, please.
Thank you. I appreciate it. I obviously see the need to avoid Me Too comments here uh, with so many participants. It is just impossible. But the issue here is so fundamental to us that I just want to weigh in and agree with the comments that have been made on the operations plan. The one thing I'd add is that it's necessary but not sufficient that any operations plan be consistent with the CEQA documentation for the project. Not sufficient for the purposes of the board because and of this proceeding, because the mere consistency with the CEQA documentation doesn't really provide a lot of informational content that we need to present our cases in chief. So that's the small bit that I'd want to add to what others have well said about the operations plan. Thank you.
Thank you. Mr. Ferguson.
Yeah, initially, I just want to comment that a number of folks were talking about project impacts in their comments that just preceded me as a basis for needing to see the operations plan. The vast majority of those issues that were raised are covered in the EIR, EIS, and so folks can review it for the handling of those issues. I will say during the break, we had a bit of an internal conversation, and Sites is prepared to put together a draft operations plan for its case in chief by May 24th. And so it'll be in the record. Folks can cross-examine the authority on it and then proceed to present rebuttal evidence in response to that plan.
Thank you, Mr.
And with
Ferguson.
respect to the agreement with DWR and the Bureau of Reclamation, that Mr. Bussey may not like to hear me say this, but that will need to be consistent with the operations plan and what's in the EIR, and need to follow along from the details of those documents. And just so folks are aware, I mean, that document is primarily to protect everybody's water rights that are part of that agreement. So it's not so much about specific. Well, I'll just leave it at that. That's the majority of the content of the document. So
thank you, Mr. Ferguson. Dr. Curdy, I see your hand went up, please.
Yes, thank you. Once again, in response to Mr. Ferguson, thank you, Dr. Quincy. How do you pronounce your last name?
Kenzie, ignore the U is usually how I describe it.
Okay, Dr. Kenzie.
I'll correct you again. I'm not a doctor, although it's. But Officer Kenzie is fine. Thank you.
I just want to, I am a doctor. Just call me Giorgio. You don't need it. Nobody. It's not a big deal. Again, to correct Mr. Ferguson, when he states that most of the issues have been brought up in the CEQA document in the EIR, that is another attempt to whitewash what the EIR is doing and for whom and for what. And what I mean what it is doing, I mean how it is helping perpetuate a certain system and practice around water allocation, water commodification, and how it is eroding the capacities of a people to continue with their traditional cultural practices and identities through processes of ecological relationship, health, and well-being. Within that context, it then becomes troubling when we continue to have to reinforce the tribal perspective, the tribal knowledge, the tribal insight. Something important is the indigenous knowledge of the people of Calusa is an aspect of best available science, as explicitly recognized by the White House in 2022. So within that context, when we talk about speeding things up or slowing things down, it's again concerning where they're trying to develop this document, they said June, July, and now they're saying May. So it's again, speeding up what should be slowed down. As other folks highlighted, it's fundamental to get this right. Jerry Brown, the executive director, if I got his title right, of Sites, stated that if this project does not make a profit, it will not go through. that raises an interesting question around this idea of this water allocation being so important for California, so important for local communities. We know 75% of the water is allocated to go to Southern California. So I think within these contexts, we need to be very careful of what has been done to date, what has been sped up that needs to be slowed down, and what needs to be slowed down that needs to be sped up. For example, indigenous knowledge insights from the people of Calusa and other affiliated tribes. One other important layer to this is, yes, reclamation is involved. Reclamation is the lead federal agency. Reclamation is developing a programmatic agreement. Representative John Garamendi on his website has stated that he has secured, I'm not sure how firm it is, but a $2.2 billion loan from the Environmental Protection Agency. In 2014, the EPA released their own internal policy document on their responsibilities and 17 principles for Indigenous environmental justice. If money is coming from EPA, that needs to be built into every line of this process. This is not a convenience or a guardrail where, well, it doesn't fit our timeline. It doesn't fulfill our predetermined and pre-decisional processes as what has occurred to date. When we talk about the CEQA document, it was predetermined. The outcome was predetermined. So let's be very clear, and this we have in writing. This is a matter of the public record, that the no project alternative, the no action alternative wasn't even given the appropriate weight of consideration. We have that in the public documents, in public letters from the tribe, in communications where Sites has admitted that. The Sites Project Authority has admitted that. So as we're having this discussion, we would really appreciate transparency. We would really appreciate that there's a rigorous attempt at identifying what the direct, indirect, and cumulative adverse effects and significant environmental impacts will be on the people of Calusa, on the greater traditional cultural land waterscape, on other affiliated tribes and other communities, on the public. When we're trying to rush these things, again, that's only working in the interest of this notion of efficiency, which means profiting off resources that are far more than quote unquote resources for the people of Calusa. They're fundamentally important. Their integrity and their health and well-being is fundamentally important for their capacities of collective continuance, for viable presence and futures. Thank you.
Thank you, Dr. Curdy. It is certainly, and as I laid out in the beginning, the intent to develop a rigorous process here for collecting the relevant evidence for making a decision. And we will continue today to talk about the scope of this proceeding. I just want to be clear, though, once again, that the board is not the lead agency here. So we have a CEQA document and it is certified, and that is what it's there. That said, that's not the limitation of on the board's authority. The board has sources of authority other than CEQA, many sources of authority other than CEQA. So I just want to respond in that way. Mr. Schutz.
Good morning. I think it's still morning. I'd like to respond to the proposal from the authority to produce an operations plan by May 24th, simply talking about that narrow issue. And their proposal procedurally then to present that as part of their case in chief and then to allow rebuttal. First of all, May 24th seems like a good date. Would like to see an operations plan or something like that by that date. Not clear to me whether that would include the agreements with BOR and DWR. I believe it needs to for the reasons that Mr. Mooney and others have articulated. I also don't think that the procedural recommendation that folks be able to deal with that or respond on rebuttal is adequate as a procedural step for the interests of the protestants. To begin with, rebuttal is limited to what's presented by the indirect in the case in chief, and there may be issues that are outside of what's actually presented. So that would limit the ability of folks in their cases in chief to address the overall operations. I would recommend on this narrow issue, an alternative path would be for the authority to put forward its draft operations plan, including the agreements with DWR and BOR, and that we have a certain amount of time. We requested 60 days to review that prior to the requirement that testimony be submitted. And that seems like a reasonable alternative. If the date for submitting a statement of what cases in chief would include were sometime after the release of the operations plan, that would probably accommodate our needs for that sort of sequencing as well. It's not, this is not ideal from our perspective. There's a lot of other issues involved, but simply on that narrow issue, in order to deal with appropriate sequencing of what these folks are actually planning to do and how they plan to operate, that seems like a potential limited delay that would allow the proceeding to go forward, but would not prejudice us by having this sort of stutter step kind of approach that is proposed by the authority. Thank you.
Thank you. I'm going to turn to Mr. Boucher and then Mr. Ferguson.
Thank you, Hearing Officer Kinsey. Eric Busher for the Baykeeper protestants. I just want to add one thing to what Mr. Schutz said and others have raised here, and that is, and if we do postpone the evidentiary deadlines, we think that should apply to the disclosure of case-in-chief witnesses as well, that should happen after, right, all of the information that we're going to rely on is gathered, whether that is at the end of May and the operations or some later date, because we're folding in the ITP and the DWR Bureau agreements as well. Thank you.
Understood. And let's see. Ms. Meserve, did you take your hand down or did you on purpose?
I was attempting to use the thumbs up.
Oh, okay.
Let's move.
Yeah, great. Mr. Ferguson, please.
Yeah, when I previously said that the operations plan would be consistent with the EIR, I was referring to the operational details in the EIR, which are, again, spelled out there. So to the extent folks are concerned about being able to review those and put a case in chief together consistent with your proposed schedule, they can start doing that by reviewing the details in the EIR. They can then take the details that are in the operations plan and further respond to those through, again, cross-examination, rebuttal. And that should be, there's more than adequate evidence out there at this time for all those pieces to move forward on the schedule that you've laid out. And there's no need to delay. And again, there's no need for the agreement with the Bureau and DWR to be in place before the hearing proceeds either. Again, that in large part is intended to protect the three parties to that agreement. It's not intended, all the operational details that feed into that agreement and are a basis for the agreed upon protections will be in the operations plan and or the EIR. And so there's nothing new in that regard that will be in that document that folks necessarily need to see as part of this hearing in order to have a fair opportunity to address the evidence with respect to operations.
Thank you, Mr. Ferguson. Mr. Porgens, I see your hand is up. If you're welcome to speak, I just wanted to say we've been through, if you have something to add, I certainly want to hear from you. We've been through a lot at this point, but please, if you have additional points that haven't already been raised. Sometimes the space bar works for going off mute. There you are.
Okay, thank you. First of all, unless I'm misinterpreting the California Water Code, the site's proponents do not own the water. They're looking to get a permit to use the water. In California, it's a usufructuary right to get a permit to use the water, correct? Are you with me on that one?
Yes, I would,
Okay.
but I would appreciate you tying this into the process that we're talking
I'm
about.
going to
This sounds
tie
like
it directly into
potentially-
the project
Okay,
because what
great.
we're talking about here is privatization of water. And a lot of public money, $2 billion have been expended either vis-a-vis general obligation bonds or from the federal taxpayers to double fish the anadromous fisheries. That's a failure. So we're subsidizing these types of projects at the public's expense to benefit a private entity. Now, it's my understanding that there are several projects that are before the commission, the Water Commission, California Water Commission, where they're talking about providing funds for projects such as the Tuscan groundwater. And I don't know, I'd have to go back and look and see if sites is on that list. And again, we don't know how much of this water is going to be going south. We do know it's going to go south. And ultimately, this is going to have an impact on the waters of the state. I had this particular debate with the legal attorneys from the Department of Water Resources. They got to get it through their heads. They don't own the water. And the waters of this state, based on my most recent report, was 179% increase in toxicity in the water bodies of California. So we spent all these 50 billion, and we got a mess here. So I'm getting a little concerned here because we're pushing too many things too fast, and everybody wants their thing right now. So I'm saying they need to realize they have restrictions on those permits, but the State Water Resource Control Board does not effectively enforce the water quality control laws of this state. I got them for 200 violations of their own permits back in the 90s and 2000. So yeah, I got them stealing water, 500,000 acre feet, 200 violations in their permits. You know what the board did? Opted to take no enforcement action. I mean, come on, where's the public trust here? So I want to make it understood. Anybody that's getting a permit here in California don't own the water. Let's make that clear, okay? So let's get that out of the way. And I'm here for over 50 years fighting for the public trust. That's what I do, okay? On my dime. Nobody else has done my dime. So let's just leave it. I'm going to leave it at that. Just make sure this board, that board that you represent, enforces the law. Then we'll have something where we can say, okay, if they violate the law, they're going to be held accountable. Hasn't been the case at all. Thank you.
Thank you, Mr. Porgens. I appreciate your comments. I think a lot of this needs to come into our evidentiary record. As I said today, it's not testimony. It doesn't it's not under oath. We're discussing the procedural issues. So I understand, but I have quite heard your point here that you're concerned about the process moving too quickly and not based on the relevant information. So
yeah, and a misnomer that they own the water. They don't own it.
Thank you, Mr. Porgens.
You're welcome. That's my last comment. Done.
I think we've heard quite a lot about deadlines. Number one, there's a lot for our team to think about here. I do want to open it up, given that we've already discussed quite a bit. I do want to open up because I think I had initially asked specifically about the operations plan and the ITP. So before we move away from this issue of deadlines and hearing dates, I did want to look to the room to see if there are anything else needs to be said that has not yet come out in our discussion about issue number one and the deadlines and hearing dates. And if something comes up, we can circle back, but in the interest of getting through our day, I'm going to move on. Because I would like to tackle the hard issues head on. For now, I'd like to skip. Someone is off mute. I'm not sure who. Possibly Mr. Sandino. Thank you. I'd like to skip to issue number 4 for now. And not that we can come back to 2 and 3, but I think 2 and 3 maybe we won't decide today, and they're somewhat narrow. But I'd like to skip to hearing issue number 4. I expect this will take us to our lunch hour and beyond. But I wanted to tackle these issues head on about whether there should be any changes to the hearing issues in the hearing notice. I'd like to start with those issues that were raised in the pre-hearing conference statements. Those were helpfully laid out in writing for me, so I've had a chance to read them and think about them. I think we should start with the authority. So I'll look to you, Mr. Ferguson and Mr. Hitchings. And I do want to just painfully step through some of these just to make sure I understand and we flesh out some of the issues that you had flagged here. And the first one I have noted is concern about issue 1B, which is about the standard for determining whether or not the board should grant partial assignment of the state filed application and that interaction with the public interest consideration. I think you raised that with 1B and no. Well, to some extent 1D, there's the public interest element there. And I wanted to just flesh out your thinking here because, I mean, maybe it strikes me that maybe it was just, I put it in the wrong section because it seems to me like this question is going to come up as to whether the assignment is in the public interest. But you're right, the statutory standard doesn't explicitly contemplate the public interest in that section, but then we have this companion application where public interest is a factor. So I wonder if I just put it under the wrong tab and it shouldn't be under issue 1, it should be under issue 3. I don't know that would alleviate your concern, but I want to invite your comments on that.
Yeah, thank you. I appreciate it. The point of the comments with respect to issue 1B was to properly compartmentalize the standard for a partial assignment. And as you indicated, and we indicated in writing, the statute doesn't specifically use the general term, the public interest. Certainly the legislature has spoken on a couple of public interest factors that it has determined are important in considering whether the partial assignment should be granted. And those are in Water Code section 10,504 and 10,505. I just didn't want it to be suggested that there was something more to be considered besides those factors.
Would you, I don't mean to put, I don't, seems like a high standard to say, would you agree? But are those concerns alleviated to any extent if I were to move this issue down to issue 3 to make clear that the consideration of public interest is related to the consideration of the application? That is, I mean, it really goes hand in hand with the petition. I guess I can't, maybe it's possible that the board would approve the assignment of a state filed application, but then deny the application. I mean, I guess that is a possible outcome, but
yeah, I'll just offer, yeah, I don't disagree with the public interest being an issue with respect to issuing the permit.
Okay. I think that's helpful. Thank you.
Okay.
And then issue 3A1 is my next on the list. Your point here is well taken. I think some modification of this, I mean, the water availability analysis is important, but I understand well, I'll give you a chance to chime in, but my understanding of your position is you have to look at all the, it's the task here is not to pick which is the best estimate. The task is to look at all the available information and evidence and for the board to consider all of that in its consideration of whether water is available. I did want to make the comment just as a matter of clarification so that we can have a further conversation if we need to. It's my understanding that a substantial evidence standard is a standard of review and that the board's standard that they're applying here is a preponderance of the evidence standard. And I just wanted to put that out there because I think sometimes there's confusion about that. I mean, on review, if this goes, well, if the board were to act and then this were and approve, for example, approve the permit, this is not a forecast of where this is going. I'm just talking about standards of review. Then a court would look at substantial evidence. But here we're looking at weight of the evidence, I think, unless you want to correct me. And if you think I'm wrong, then you should correct me in a legal argument somewhere along the line in the process. But I'll turn to you. Is there anything else you want to add on my consideration of your comments on issue 3A1?
No, and I don't disagree with your comments about weight of the evidence.
Okay.
And yeah, you accurately summarized our concerns about the use of the phrase accurate approach. So.
Thank you. I appreciate that. And then once again, I'm just stepping through and what I'll do is I'm going to step through all of these and then I'll look to the room if others want to. I'm having an exchange with Mr. Ferguson and possibly Mr. Hitchings, but then I'll look to the room if anyone else wants to make a comment on these. Issue 3A33, which is unfortunate. I'm sorry about that. With this question about the applicability of Fish and Game Code sections 2053 and 2055. I think I see that as that this is a substantive disagreement that you have about the extent of the board's authority. And I don't mean by raising this as a hearing issue, I don't mean that to be a done deal, you know, that the board's made a determination that our authority is or isn't there. But I do think it's a live issue in the hearing and one that should be addressed. Sounds like some in legal elements by the parties. So my inclination would be to keep it there. And excuse me while I had notes and now I've lost them. Here we go. But one of my questions here is, because it does affect the scope of the proceeding, I wanted to explicitly ask you whether you think it would be important to have legal briefing sooner rather than later on the applicability of those sections of the Fish and Game Code, or whether we can address it in essentially in closing briefs. I'm putting you on the spot, but you know, this is we can come back to this too if it's something you'd like to, you know, come back to after our lunch break.
Well, I'll just offer that the authority is going to have evidence in the record about potential impacts to endangered species, and that's related to a topic we already discussed, which is the ITP. And the authority can otherwise present evidence with respect to potential impacts on endangered species. And so those sorts of analyses will be incorporated into the authority's case in chief and potentially rebuttal, and then potentially a subsequent portion of the hearing, which we're proposing. My point is that the State Water Board doesn't otherwise have the independent authority or obligation to apply the jeopardy standard in evaluating what in-stream flows may or may not be necessary.
Understood. Thank you. And then my final issue that I wanted to talk about with you was issue 3B. And I know there's this, as you pointed out, the open question about the applicability of Water Code sections 1215 through 1222 if the board were to approve the assignment. But I wanted confirmation on issue 3B. If the board denies the petition for assignment and moves forward on the application, then this question would be relevant, wouldn't it? Should be part of the hearing.
Well, that assumes that you would establish a priority date with the date the application was submitted.
Right.
Correct? Is that the assumption you're making?
Yeah, if that were to be, that's one possible outcome of this proceeding, right? Is that the board denies the assignment but approves the application. I mean, possibly we can argue about whether legally that could happen, unless that's not something the authority wants. if the authority wants this to be considered as a package only, that probably is an important thing for us to establish in advance, because it would help narrow the scope of the hearing.
Well, I'll say right now, the authority is looking to have the board approve the 1977 priority date, and I would need to have some further internal discussion before before I offer a different position. I see your point that if there was a priority date later than 1985, which is I think the date that Water Code section 1215 to 1222 concern, then yeah, I would agree this could potentially be relevant.
Great, thank you. And then I didn't have anything else, but Mr. Ferguson, are there other, obviously I read your statement and I will reread your statement carefully, but is there anything else you wanted to raise on the hearing issues at this time? And you'll have a chance to respond to others who have raised issues, but just from the...
No, I do not, thanks.
Thank you. Mr. King, I'll turn to you.
So thank you. So first of all, I want to acknowledge the points made by Dr. Curdy, and the namesake of my protest, T&M King Farms, is Thomas and Martha King, who actually settled on patent lands that have been held by the patent people from since time immemorial. So if it wasn't for the legacy that the European settlers had, I wouldn't be here protesting. And the basis of my riparian rights, I'm alleging, goes to a grant from President U.S. Grant to my great grandparents giving on overflow lands. So with that in context, I'm coming from a point where I think the application date should be a 2022 application date, and everything should flow from that, because I think that really represents like the complexity of California and today, and all the environmental concerns, and then the tribal interests like AB 52. I believe that why I understand why the Sites Authorities Council tried to narrow the issues. I think that's not in the best interests of this process, because they are complex, and especially when it comes to tribal consultation, we really need to acknowledge and respect tribal ecological knowledge in this process. And I believe there are a lot of water quality issues that are important to the Colusa Basin himself, that we could gain knowledge from the indigenous history and how that may play out. But I also want to point out that regarding the 1985 date, I think that's an arbitrary date, and I made it in my comments, and I only responded because the authority made those comments, is that you had a specific act of legislature in the Colusa County Flood Control and Water Conservation District Act, was enacted in 1983, which has some air of origins concerns, and it really talks about what's best for the Colusa County as a whole. And then in 1987, you had a Colusa Basin Drainage Act, the specific act of the California State Legislature, which talked about the regional issues facing the Colusa Basin Drainage District, which is over 1 million acres, encompassing most of the Colusa Subbasin and part of the Yellow Subbasin. So that in itself, really, you can straddle the 1985 date. Beyond that, I'm a graduate, Colusa High School, grew up in Colusa in 1977, so I remember the drought in 1977 well. And as a high school student, I knew I had a drought. I did not know about the state's right, but I did what I could, and I made the applications personally that I right now I do not have subordination for permits filed in 1980 and 1982. So I really look at this whole issue of 1985 as sort of an arbitrary issue, and that we really should look at everything from the context of what the public interest and all the different socioeconomic and policy issues from with a 2022 application date. Regarding Section 3, the water measurement, I believe what's most important is what happens to water in the drain, in the Colusa Basin drain, and specifically for my interest, and I think for the general interest, what happens as it passes over the Davis Weir Dam. It doesn't matter what, and then also with the intended diversions of Stone Corral and Funk Slough, because of this, which I don't think will ever touch the drain, which is historical watershed, but there's been artificial and really, I believe, a negligent drainage regime put in place over the last several decades. And what's important is that the environmental water flows down the drain. And what's most important is how I believe there are two unauthorized dams in the system, Maxwell and Glenclusa, that restricted flows, natural flows, and we need to measure water going over the Davis Weir Dam and going down the drain and the environmental water. So one is that I believe state legislature has it's two specific acts talking about unique aspects of the Clusa drain. Sigma's come in, another consideration, AB 52, putting the preeminence of tribal consultation. That all can be wrapped up by looking at everything from a lens of the 2022 application date. And then regarding action measurements, we should actually see what actually the physical water that's available for both the beneficial and stream uses and also the prior appropriate rights.
Thank you, Mr. King. I want to acknowledge you raised the issues that you had identified in your pre-hearing conference statement. So, and I want to acknowledge that I read your statements, and I think a lot of the sub issues that you raise are within the scope of the hearing issues that are laid out. That the public interest is broad. I explicitly wanted to acknowledge your comments about Sigma implementation. There's connection there with potential injury to senior water rights, and then also a public interest element. And I am going to consider whether, particularly with respect to Sigma, that should be called out explicitly, but I in the sub issues, but these sub issues in the hearing notice for all of you they're not intended to be exhaustive. It was intended to lay out to some extent what elements we think might be important, but that doesn't mean that we've thought of all of them. So thank you, Mr. King. I appreciate that. And I'll turn to the room. I think we did two at once in some ways, but that was efficient. So thank you, Mr. King. Does anyone have any response to either, not response, I don't want to frame it that way, but additional comments on the exchange I just had with Mr. Ferguson and then also with Mr. King? And it looks like I see Mr. Schutz first, so I'll go to you.
Yes, thank you. Regarding issue 1B, it was unclear to me how the question, I understand that the public interest is not at play in deciding what the priority date is of a state filing. However, it seems like the public interest would be at play in the board's decision about whether or not it would assign a state filing to the site's application. And it was not clear to me what the basis otherwise would be for sites getting or not getting the assignment of a state filing. And it seemed to me as though the issue of the public interest kind of got lost in the question of what the assigned priority date was of the state filing, whereas the question, as I read it, had more to do whether as to whether it was in the public interest to assign that state filing to sites.
I understand you. I'm thinking. Yes, I think I share that. I think it does both, right? It's I don't see the way you're right. The way the question is phrased, it could suggest a narrowing that the only relevant consideration of the public interest is the relative priority dates. So I will think about that.
And the sort of conclusion then would be that it may be appropriate in some shape or form to continue to include discussion of the public interest in 1B or whatever its successor might be, as in addition to moving it down to the question of in section 3 about whether the application should be granted.
Yes. So what I hear here is there may be, excuse me, here is there may be a substantive legal dispute over the consideration of the public interest with respect to assignment of the state filed application. And if which appears to be a live legal issue, it may be appropriate to raise it as a hearing issue, which is not to prejudge to say that the board thinks it's one way or the other, but that this is an issue that the parties should be briefing and addressing. So I will consider that. Does that capture? Do you think I understand you?
And if it's not public interest in part on which the consideration of the assignment of state filing would be granted or not granted, I guess the question would be, what would the criteria be? And it also goes to the issue of what you asked before as to whether the authority was prepared to stipulate that if it did not get assignment of state filing, it would not pursue its application for a water right, which I would presume would not be something the authority was prepared to stipulate.
Thank you, Mr. Schutz. Mr. Mooney.
Thank you. In reading through the authorities' proposed changes to the hearing issues, it seemed to me that what they're doing is really trying to limit the scope of the scope of the board's authority in terms of what the board can and can't consider. And my notes as I was reading this was this is an argument for closing brief. And I know the hearing officer, you were making comments with respect to that, and so I just wanted to support that to the extent that there's a dispute over the state board's authority, whether it be under Fish and Game Code 2055 or consideration of public trust, those hearing issues need to be left in, because I think we need to be able to create the record for the evidence, and then everybody can argue the scope of the board's authority, in a closing brief. If we're if the board at this point says, well, we're not going to consider these issues, and then we will end up being precluded from presenting evidence on those issues, and then we won't have a complete administrative record in terms of, what is the board's authority, and if the board has that authority, how should it exercise that authority based upon the evidence in the record. So I would encourage that these legal issues that are identified, that are really disputes over the board's authority, be reserved for closing briefs.
Thank you, Mr. Mooney. I think that's exactly the issue I was trying to tee up here, and was one of the bases for my question to Mr. Ferguson about, we have this balance. You're recognizing there's this balancing of, do we just go forward with and gather all of the evidence and then work out these legal disputes in closing briefs, which I think often is the most efficient. On the other hand, there is some argument to be made for we should confront them up front through briefings. I mean, everyone should have, not just this conversation, but through legal briefings, have a pre-hearing decision on the proper scope, and then go forward from there. There are pros and cons to both approaches. In general, in my experience, it's more efficient to just go forward with the hearing and deal with all of these in the closing brief. But I wanted to acknowledge that some of the consideration that I'm thinking about here with respect to these issues.
If we were going to do briefing on them ahead of time, I think that would require us, the board, pushing out the deadlines for witnesses and preparation of testimony, because it would be, I don't want to be preparing testimony on something that the board later determines that it's not going to be a hearing issue.
Right. That would
everybody's limited resources.
Maximum inefficiency. So we won't do that. Was there anything else, Mr. Mooney?
No, that's it.
Thank you. I think I'd like to go to Mr. Fisher, and then I'll return to you, Mr. Ferguson. Mr. Fisher.
Hi, thank you. So I want to respond to 1B and maybe one other issue. The board, as I think we agree, has broad authority to protect and avoid harm to public trust resources. The explanation by sites under 1B is that under this specific code, the water board shouldn't otherwise consider public interest in assigning an SFA. Well, that's one specific code, but there's other laws that apply here. So I think it just might be worth considering whether the board's broad public trust authority to avoid harm is applicable under 1B, and that while the description of Water Code section 10,500 might be true, that's maybe not the only law applicable. Down to 3A 3.3. Similar argument. I mean, the CITES pulls out a specific law that doesn't specifically say the water board has the authority to protect or avoid harm to endangered species. But again, there's other laws at play. So I just want to address this pattern. And I think broad authority of the board is probably going to be an issue that keeps coming up. It certainly came up in our discussions with Mr. Ferguson and others. That's it.
Thank you, Mr. Fisher. Mr. Ferguson, back to you.
Yeah, the authorities' point in raising this issue and requesting that it be struck was to constrain the issue to accurately reflect the scope of the board's authority. And with respect to this issue, which deals directly with a partial assignment, there are statutory provisions that lay out the standard for a partial assignment. And the goal here was to not provide an opportunity for other parties to submit evidence on issues that aren't related to those standards as they're stated in the statute, because ultimately the board's going to make a determination about the assignment by evaluating the standard that's laid out in the statute. And so that's really what we're asking for, is that there not be this other potential factor that's considered that's called the public interest. Because again, the legislature has spoken with respect generally to the public interest factors it found important in evaluating a partial assignment, and those are laid out in the statute. So folks, I think Mr. Schutz raised questions about what sort of evidence might we be able to submit. It should be related to those standards spelled out in Water Code section 10,504 and 505. That's the relevant category of evidence for this issue of a partial assignment. And that's why we were requesting that the issue be struck in its current phrasing or otherwise revised, as we talked about at the beginning.
Understood. Thank you. It's 12:14. We haven't gotten to CSPA and Friends of the River. You had some particular issues that I did want to step through in the same way we just stepped through the authorities' comments. And then, of course, I want to turn to the room and see what other specific issues related to the hearing issues should be addressed. My inclination is to take a break, our lunch break now, and then come back and pick this up. We have moved along somewhat more quickly on this than I thought. I know I said half an hour, but let's go ahead and, for all of our sakes, we've all been working hard. Let's give ourselves 45 minutes. I'd like to return at 1 o'clock. I think for our Zoom recording, we have to, and for YouTube streaming, we will have to kick everyone out, and then you will be able to log back in. So you can go ahead and once we take our break, log out and then log back in a little before 1 o'clock. But before we break, is there anything else we should address in this moment before we return at 1 o'clock? All right. Well, thanks to all of you for hanging in there with us. I think this is really productive. I know it's been very productive for me, so I really appreciate everyone's participation. Have a good lunch, and I will see you at 1. Thank you.